Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, Judge of your Webb County Court at Law 2. This is the Family Law Docket for Thursday, April 16, 2026. The time is now 2:01. Court is now in session. Assisting us today is Cynthia Flores, Family Law Court Coordinator. Court recorder is Ms. Cecia Rodriguez. Our interpreter is Mr. Ubaldo Cuellar. Video conference co-hosts this afternoon include Ms. Reyes, Ms. Rodriguez, Ms. Ramos, Mr. Hernandez, Ms. Lozano. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Flores.
Yes, Your Honor. First case in person is Attorney Jose Luis Castillo, page 3, number 7.
Yadira Yacel Salvador versus Enrique Salvador, cause number 2025 FLA 1446C3. Good morning, Good afternoon, Mr. Castillo.
Good afternoon, Your Honor.
Court marks you present in person. Olivero Canales, are you present?
Judge, he is not present, Your Honor. He did file a motion for continuance, Judge. I believe he's in a conference. I am unopposed to it, Judge. He extended a courtesy to me last time, and I'm extending the courtesy back to, subject to Your Honor's approval.
By agreement, professional courtesy, and due to attorney unavailability. Ms. Catherine Garcia, any objection on behalf of the Attorney General's office?
No objection, Your Honor. Thank you.
Court has heard no objection. There being no objection, and for the reasons stated on the record, the request is well taken and granted. Ms. Flores, would you give us another date, please?
May 5th at 2 p.m.
Any objection to that date?
No objection, Your Honor.
May 5th at
2 p.m.
so ordered. Any other cases for Mr. Castillo?
That is all for Mr. Castillo.
First in, first out. Good to see you.
Let me excuse, Your Honor.
Yes, sir.
Thank you, Judge.
Next case, Attorney Andy Reyes, page 5, number 13.
Case 13 is Lourdes Hernandez versus Juan Ernesto Charo, cause number 2026 FLA 95C3. Good afternoon, Mr. Reyes.
Good afternoon, Judge.
Court martial present in person. Ms. Maddox, Adriana Maddox, are you present?
Judge, she's not going to be present today. I understand maybe she might be a little bit under the weather. But be that as it may, Judge, we filed a joint motion for continuance. Parties have informed us, Judge, that they are in the process of trying to reconcile. And so we'd ask the court for the court's indulgence, Judge, to give us some time, 60 days, to see if they in fact work it out.
Sure. Court has received, reviewed, and considered the motion for continuance. Court has written in possible reconciliation merits additional time. The request is well taken. Ms. Flores, on this case, give us 60 to 90 days, please.
July the 30th at 2 p.m.
Any objection to that date?
None whatsoever, Judge. That's fine. I'll inform Ms. Maddox.
Any other cases for Mr. Reyes?
That is all for Mr. Reyes.
Good to see you. Have a great day.
Judge, it's always good to see you, Judge.
Thank you.
Take care.
Your Honor, Catherine Garcia with the AG's office. If I could make a quick announcement on this case before Mr. Reyes
I think
leaves.
Ms. Garcia wants to make an announcement. Ms. Garcia, I can hear you, but you're coming in really low, just FYI.
Oh, wow. Okay. It must be my speaker.
She's fine. It could be the speakers in the courtroom, Your Honor.
So it's us, not you. Go ahead.
Judge, there's a prior SAPSER order running on this case, and the cause number is 2005 CVO 001280C1. The AG's office at this time is not going to be making an appearance on the divorce case, but I did want the court to know so that whoever the petitioner is in the divorce can file a transfer and consolidation from County Court 1 to County Court 2.
So I guess the thing here, Mr. Reyes, if the parties don't reconcile and do want to get divorced, just have the AG case transferred in here.
Judge, for the sake of judicial economy, I would agree that it be consolidated if in fact, they don't reconcile.
Sure. Just please, so let them know before, so they can make a decision before, so that we can be transferred and we go straight to a final on July the 30th.
Very well, Judge.
All right. Thank
Good seeing
you.
you, Judge.
Likewise.
Next case, Attorney Victor Villafranca, page 2, number 4.
Daniela Espericueta versus Oscar Eram Ramirez, cause number 2019 FLA 1411C3. I believe Mr. Villafranca is outside. Our Sergeant at Arms is asking for his whereabouts. Jose Salvador Tellez, are you present? Court marks counsel not present. Daniela Espericueta, Oscar Eram Ramirez. Any litigants present? Court marks Mr. Villafranca present in person. Is this your client?
Yes, Your Honor.
Court marks Ms. Espericueta present in person. One more time, Jose Salvador Tellez or litigant Oscar Eram Ramirez, are you present? Court finds neither of those persons are present, and court marks Ms. Salazar, court's appointed ad litem, present by video conference. Good afternoon to all.
Good afternoon, Your Honor.
The announcement?
Your Honor, Mr. Days and I have submitted 2 motions, Your Honor. One of them was for an informal settlement conference. We believe we should be able to work this out through this meeting. We were hoping we can get it with Associate Judge Leticia Martinez, if she were available, Judge. We'd like to try that. And along with that motion, we did file a motion for continuance in order to give us time to have that meeting, if possible, Your Honor. The reason why this is coming up right now, Judge, is that the ad litem report had come out after the last hearing we had. I believe we were waiting for it the last time. So it did come out, and because of the report, I guess not really get into it, but it really can affect some serious change that I believe we need to bring up, Judge. And I think through an informal settlement conference may be the best avenue at this moment.
Any objection to May 26th?
I have no objection to that. No.
Mhm.
Is that for the informal conference?
Yes.
That sounds good to me, Judge.
Me calendar this in for Associate Judge Martinez. All right, so it is now on Associate Judge Martinez's calendar. All right, so just let Mr. Tellez know, although I've written it into the order, so the parties must be at mediation on that day. The continuance is granted. Give us a setting after that date, Ms. Flores.
June 4th at 2 p.m.
Any objection to that date?
Sorry, Your Honor.
Ms. Salazar, I saw that you had a motion. Do you want to argue that?
Your Honor, actually, that motion was more of a placeholder. I I just wanted to inform the court that I recently did accept a position with the Webb County Public Defenders. And I did speak with my employer and they said that I would be limited in my participation in legal private matters. So that was really the only reason why I filed that motion. However, they did say that in certain circumstances, I could continue to do private work to close out existing cases. So I don't know if right now would be the best time, but I wanted the court's guidance to see whether or not you would prefer to keep me on, or if you would prefer to have me withdraw from the matter.
So, lot of things to contemplate. So one, you've already issued out a report in this case, correct?
Yes, Your Honor, I did issue the final recommendation and report, and the parties have paid their fees. The court
Yeah,
ordered.
so for that reason, I'm going to keep you on this case, but you're going to continue on this case unless and you should stick to that report unless there's a change in circumstance since the date of your report. So Mr. Villafranca and Mr. Tellez need to let you know as the continued court appointed ad litem in this case if there are any changes. You can come back on the day and you can still bill for whatever work you do. And I think what I had thought about asking, because I am now familiar, not with you, but with others in your now employer's position, that lawyers are employed by Webb County, but do practice civil law on the side in family law cases. So I guess the standard, I guess that the court should set is that if lawyers are going to work for the county and practice family law, then they should be subject to appointments. However, if you tell the court that you're going to be an employee of the county and not practice law for at least 2 to 3 years, then I can see how an argument can be made to keep you off the list. But if folks are going to be making appearances in family law, then everybody should be appointed. So at least in this situation, just stay on, and the lawyers will let you know if there's any changes that need to be made to your report.
Okay, thank you, Your Honor.
All right, we'll see everyone on June the 4th at 2. I wish all persons well.
Thank you, Your Honor.
Have a good
you.
day.
That is all for Ms. Salazar. For Mr. Villafranca,
It's good to see you, Ms. Salazar.
Thank
Page
you.
10.
Number 10 is Mario Alberto Valadez Jr. versus Jocelyn Ventura, cause number 2025 FLI 276C3. Court marks Mr. Villafranca present in person, Ms. Catherine Garcia present and participating by video conference. Mr. Mario Castillo III is present in person. Speak in front of the microphone and tell the court, are you Marto Alberto Valadez Jr.?
Yes, Mario Alberto.
Welcome to court, Mr. Valadez. The court marks you present in person. The person to your right is your lawyer. Mr. Villafranca, is this your client on your left, now right? Welcome to court, Ms. Ventura. The court marks you present in person. Your lawyer is on your left. Mr. Castillo, Mr. Villafranca, go ahead.
Your Honor, we're conferring. Let's get a little bit of time. Looks like we should have an agreement.
Inaudible.
I'm still conferring with my client, Your Honor. We can get just a little time.
All right, without knowing anything else, the court will mark this case as the first contested matter today. Continue to talk to your lawyers. Good luck.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Next case for Mr. Villafranca, page 5, number 12.
Adriana Olivares versus Juan Olivares Jr., cause number 2026 FLA 91C3. Court marks Mr. Villafranca present in person. Adriana Olivares, Juan Olivares Jr. Any parties present? I'm going to ask that each of you step in front of different microphones. Tell the court, are you Adriana Olivares?
Yes.
Welcome to court, Ms. Olivares. The court marks you present in person. Speak into the microphone and tell the court, are you Juan Olivares Jr.?
Yes, sir.
Yes.
Welcome to court, Mr. Olivares. The court marks you present in person. Mr. Olivares, do you have a lawyer?
No, sir.
Will you be going forward today without a lawyer?
Yes.
All right, court marks you self-represented. Mr. Villafranca?
Your Honor, for the record, Mr. Olivares was not served, but he is present, I guess, making a general appearance. I think we're ready to proceed on an agreement, Your Honor.
This is an agreement for a final hearing. This is
Final hearing. Yes, Your Honor.
Mr. Olivares. Mr. Villafranca says that you're ready to hold the final hearing. Are you ready to do that?
Yes. Yes, sir.
And are you ready to hold the final hearing, Ms. Olivares?
Yes.
All right, Ms. Olivares, Mr. Olivares, I'm going to ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Both have answered yes. You may lower your hands. Mr. Villafranca, go ahead.
Can you please state your name for the record?
Adriana Olivares.
Ms. Olivares, you're married to Juan Olivares Jr.?
Yes,
Now, Ms. Olivares,
Inaudible.
you were married on or about July 22nd, 2011, is that correct?
correct.
Ceased living together, separated on November 1st, 2025.
Yes,
Now, you lived in Texas for the past 6 months,
yes,
Webb County for the past 90 days.
yes,
Now, you asked the court to grant you a divorce in this case, is that correct?
correct.
Now, that is because the marriage has become insupportable because of discord or conflict of personalities between you and your husband,
Correct.
and that destroys the legitimate ends of the marriage relationship, correct?
Yes,
And it prevents any reasonable expectation of reconciliation.
yes,
Now, you have come to an agreement with Mr. Olivares, is that correct?
correct.
Now, you all own, as part of that agreement, you all own a home located where? Yeah.
327 Color Loop.
Okay, now with that homestead, you all are already in the process of selling, correct?
Correct.
And you all have agreed to split the equity evenly, is that
Yes.
correct?
Yes,
And for the furniture also
Yes.
evenly?
Mhm.
Now, you have agreed to keep the 2025, I'm sorry, that he keep the 2025 Kia, is that correct?
Yes.
And you keep the 2004 Chevy Trax, is that correct?
yes,
Now, there's still a note on that vehicle and you've agreed to take his name off of it, correct?
yes,
Now, as for retirement, you've agreed that you keep your retirement and he keep his own retirement, is that correct?
yes,
Okay, now as for, and whatever personal property you may have in your possession, he has his possession, you all keep that, correct?
yes,
Now, as for custody and visitation, you all have agreed to joint managed conservatorship with you determining the primary residence of the children, is that correct?
yes,
Okay, and right now in medical insurance and dental insurance is provided through his employer and he's going to continue paying that?
Yes.
Okay. You agreed to standard visitation, is that correct?
yes,
Now, as for child support, we did come up with some numbers and you've agreed to that. The number is $982 a month and 67 cents. Is that correct?
Yes.
$982.67 a month. Is that correct?
Yes.
Okay. Now, you also asked the court, you all have agreed that your name would change from Adriana Olivares to Adriana Macias. Is that correct?
yes.
Okay. You don't have no further questions of my client.
Mr. Olivares, do you have any questions to Mrs. Olivares?
No, sir.
Any other witnesses, Mr. Villafranca?
No, Your Honor.
Mr. Olivares, is there anything that you would like to tell the court?
No.
Did you hear and understand all of the requests that are being made by Mrs. Olivares?
Yes.
Is that your agreement with her?
Yes, sir.
Is that your full agreement?
Yes.
Was anything left out?
No.
Is there anything you want to change?
No.
Do you believe that this agreement that you have with her is in the best interest of your children?
Yes, sir.
Do you believe that this agreement that you have with her regarding the division of your property, do you believe that to be a just and right division?
Yes, sir.
Has anybody forced you to enter into this agreement?
No, sir.
Have you entered into this agreement freely and voluntarily?
Yes, sir.
All right. Is there anything else you would like to tell the court?
No, sir.
Anything else?
No, Your Honor.
Ms. Olivares, Mr. Olivares, in your case, cause number 2026 FLA 91C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage on the 22nd day of July of 2011, but you stopped living together as husband and wife on the first day of November 2025. The court finds that your marriage has unfortunately become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were children born in the marriage. No other children other than those were born, adopted, or are expected. The court finds that you have an agreement regarding your children. The court hereby adopts and approves your agreement in full and finds that that is, in fact, in your children's best interest. The court likewise finds that you have an agreement regarding the division of your property. The court hereby adopts and approves your agreement in full and finds that your agreement is, in fact, a just and right division. At this time, Ms. Olivares, the court changes her name to Adriana Macias. And at this time, Ms. Macias and Mr. Olivares, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due on or before
May 18 at noon by submission.
That will now conclude your case, Ms. Macias. Do you have any questions for the court?
No.
Do you have any questions for the court, Mr. Olivares?
No, sir.
I wish you both very well. More importantly, I wish your children all the best. Good luck.
Thank you.
Thank you.
Last case for Mr. Villafranca, page 6, number 17.
The matter of Isaac Arturo Guerrero, cause number 2026 FLK 396C3. Court marks Mr. Villafranca present in person. Is this your client behind you?
Yes, Your Honor.
Court marks Mr. Isaac Arturo Guerrero present in person. Mr. Villafranca, what is the announcement?
Your Honor, we are ready to proceed on an original petition for name change.
Mr. Guerrero, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir. Yes, Your Honor.
You may lower your hand. Mr. Villafranca, go ahead.
Can you please state your name for the record?
Isaac Arturo Guerrero.
Now, Mr. Guerrero, you're petitioning this court for a name change, is that correct?
Yes, sir.
Now, you've never been arrested for anything, is that correct?
No.
You've never been convicted of a felony?
No, sir.
And you're not subject to any sex offender registration, is that correct?
No.
Okay, now, you've already done your requirements by submitting your fingerprints to the state of Texas, the DPS?
Yes, sir.
Okay, and and that came back with no criminal history, correct?
Yes, sir.
You're asking the court to change your name from Isaac Arturo Guerrero to Isaac Arturo Diaz de Leon Morales, is that correct?
Yes, sir.
And that is because you don't want to have anything to do with the name Guerrero, is that correct?
Yes, sir.
That is because your father's last name is Guerrero?
Yes, sir.
And you have no relationship with him?
Yes. No, sir.
And you never attempted to have
Much louder?
What?
I just want to make sure that we have a good record. Just speak louder.
Yes, sir.
you had no relationship with your father, is that correct?
Yes, sir.
He never attempted to be a father to you?
Yes, sir.
Therefore, you don't want his name, and you're asking this name changed to Diaz de Leon Morales, correct?
Yes, sir.
Now, I believe Diaz de Leon is your grandfather's name,
Yes, sir.
and Morales is your stepfather's name.
Yes, sir.
And you're asking the court to change it to that name, correct?
Yes, sir.
No further questions, Your Honor.
It's the only questions I have, Mr. Guerrero. Are you asking to change your name for any other purposes other than your family situation?
You gotta speak up.
No, sir.
Are you asking to change your name to avoid any type of tax liability?
Money?
Yeah, are you asking to have your name changed to avoid any type of tax liability?
No, sir.
Are you asking to change your name to avoid any type of civil liability, any lawsuits or debt collections?
No, sir.
Right. Anything else you would like to tell the court?
No, sir.
Mr. Guerrero, in your case, cause number 2026 FLK 396C3, the court finds that it has jurisdiction over this case. The court takes judicial notice of the entire case file and now has had the benefit of hearing your testimony. The court finds that there is good cause, reason, and basis to grant the request. The court hereby changes your name to Isaac Arturo Diaz de Leon Morales. Congratulations.
Thank you, Your Honor.
I'm going to sign that order and you can pick up a copy as early as tomorrow. All
Perfect.
right. I wish you all the best, sir.
Thank you, Your Honor. Your Honor, may I be given an opportunity to confer with my client on the other case, and we'll approach shortly.
Yes, sir.
Thank you, Your Honor.
Next case, Attorney Brenda Anderson, page 4, number 9.
This is Blanca Rubi Arellano versus Pio Arellano, cause number 2025 FLB 1711C3. Good afternoon, Ms. Anderson.
Judge Brenda Anderson for petitioner Blanca Arellano.
Court marks you present in person. Is this your client?
Your Honor.
Court marks Blanca Rubi Arellano present and to your right. Mr. Arellano, speak into the microphone and tell the court, are you Pio Arellano?
Sí. Yeah.
Court marks you present in person. Mr. Arellano, when you were last in court, the court gave you some time to look for a lawyer, to talk to a lawyer, and to possibly hire a lawyer if that's what you chose to do. Have you had an opportunity to do all of those things?
No.
No.
What has prevented you?
Tengo otras prioridades más importantes que no he podido contactar a un abogado. Yo hablé con Ms. Anderson para tener un acuerdo.
I have other priorities that are more important right now than to find an attorney. I did speak with Ms. Anderson to try to get to an agreement.
I just want to make sure that we're on the same page, and I'm going to give you the benefit of the doubt. When you say that there are things that are more important, Do you mean that there are things that are more important than this case, or do you mean that you have other financial priorities and you would rather use your attorney's fees to pay for other things? Or do you mean something else?
Parte de lo financiero para los gastos del abogado, pues no ha habido.
Part of it is expenses for the attorney, so I haven't had money.
I understand exactly what you're saying at this point.
De pagar biles en la casa, estoy en este caso haciendo mis biles.
I have
No.
other priorities, for example, paying the bills for my house and taking care of the bills.
I understand. Ms. Anderson.
Your Honor, I did confer with Mr. Arellano and we have reached an agreement. So we could.
Is
prove
this all right? Very well, Ms. Arellano, Mr. Arellano, I'm gonna ask that you both raise your right hands. Did each of you solemnly swear or affirm that the testimony that you will give in this cause will be the truth, so help you God?
Yes, yes.
Both have answered yes. You may lower your hands. Ms. Anderson, one witness at a time, just allow for interpretation. Go ahead.
Ms. Arellano, can you please state your full name for the record?
Blanca Rubia Arellano Flores.
And you are married to Mr. Pio Arellano,
Yes,
and you filed this petition for divorce? Is that true?
yes,
And prior to filing the petition for divorce, were you domiciled in Texas for at least 6 months? And were you a resident of Webb County for at least 90 days?
yes,
Okay, and you were married on or about August 9th of 1987, is that true?
yes,
And you continue to reside together, is that right?
yes,
And you're asking the divorce today, you've reached an agreement on the grounds of irreconcilable differences, is that true?
yes,
Are there any minor children of the marriage?
no,
Okay. Now I'm gonna read onto the record the agreement as far as the division of the estate. And I ask that you pay attention. So, and I'm gonna ask you if that's correct at the end, okay? And for Mr. Arellano as well, if you could pay attention to the agreement so that I will be asking you at the end if that it reflects the agreement you have reached.
okay,
Okay, the parties have agreed that the residence located on 1427 East Orquídea in Rio Bravo, Texas, be sold. They will attempt to find a private buyer, but in the event there is no private buyer within the next 30 days, they shall list the property for sale with a licensed realtor. Ms. Arellano shall be awarded her vehicle in her possession, which is a 2020 Chevy Equinox. She shall be awarded her bedroom set, any bank accounts in her name, any other accounts in her name, including her TRS retirement account. Mr. Arellano shall be awarded any vehicle in his possession or under his name, and any bank accounts and any retirement accounts under his name as well. Regarding the debts, Ms. Arellano shall be awarded any credit cards under her name, as well as the debt on the 2020 Chevy Equinox, as well as the debt on her bedroom set with Synchrony Home. Mr. Arellano shall be awarded any credit cards under his name, as well as any other debt acquired by him or under his name. Regarding the sale of the home, there is a debt owed to Goodleap, and this is a debt on an AC unit that was installed in the home that involves a loan in the amount of approximately $15,000. And the parties have agreed that that loan that covered the AC system in the home be paid off from the top of the net sale.
We're having a bowling fun.
And after that debt is paid, then the remaining net sale proceeds be divided between the properties, between the parties, 50-50. And I believe that reflects the agreement. So Ms. Arellano, is that the agreement you have reached in the case?
Yes,
And you're asking this court to award your divorce today?
yes,
And is this division of a fair and just division of the estate?
yes.
And are you asking for a name change?
No.
Okay. Nothing further from this witness, Judge. If I can ask, oh,
Actually, Mr. Arellano, do you have any questions for Mrs. Arellano?
Pues nada más que el tiempo que tarden en venderse la propiedad, que estemos ahí, que podemos estar ahí, igual como hemos estado haciendo.
Just that, while we sell the property, can we be there as we have been so far?
Any objection?
I don't, nothing else.
No, simplemente pues tratamos de tratar de que se venda la casa y al venderse pues.
No, that's fine. We'll just make the deal that we sell the house, and once it's sold, we'll each go on our own way.
All right, without objection, Mr. Arellano, I'll let you tell the court whatever your argument is at the end, but this is your opportunity to ask Ms. Arellano any questions. You don't have to. I just want to make sure that I give you that opportunity. Do you have any questions for her?
No, parece que todo está claro.
No, I think everything's clear.
Ms. Anderson, you're a witness.
Mr. Arellano, you heard the agreement as I read it onto the record. Does that reflect the agreement you have reached in this case?
¿Me puede repetir?
Can you repeat the question?
You heard the agreement that I read onto the record. Does that reflect the agreement you reached in this case?
Yes.
Nothing further, Judge.
All right, now, Mr. Arellano, is there anything that you would like to add or tell to the court or make any requests?
No, todo está claro, como digo, a lo que me están explicando que todo sea conforme a lo que estamos hablando y adelante.
No, everything's clear. I just want to make sure that everything's done the way we agreed, and we can go ahead.
Ms. Anderson, if I missed this, I apologize. I heard irreconcilable differences. Ms. Arellano, is there any reasonable expectation of reconciliation?
I didn't understand the word.
Because it's legal. Let me see. Is there any possibility that you reconcile with Mr. Arellano?
No.
Right, Ms. Arellano, Mr. Arellano, in your case, cause number 2025 FLB 1711C3. The court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage on August 9, 1987, but your marriage has, there are irreconcilable differences that prevent the legitimate ends of the marriage relationship. The court finds that there are no minor children of your marriage, none were adopted and none are expected. The court finds that you have an agreement regarding the division of your property. The court hereby adopts and approves your agreement in full and finds that it is a just and right division. Ms. Herrero, Mr. Herrero, at this time, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due honor before.
May 18 at noon, my submission.
That now concludes your case here, Ms. Arellano. Do you have any questions for the court?
Just thank you very much.
Mr. Arellano, do you have any questions?
No. No.
Ms. Flores, remind the court, does the court have Mr. Arellano's email address?
Yes, Your Honor.
All right, so just be on the lookout for your email. Ms. Arellano and Mr. Arellano, I wish you both very well. Have a good day.
Gracias.
Thank you, Judge. That's all I have. My excuse.
Have a great day. Good to see you.
Next case, Your Honor, is Attorney Marcel Knudsen, page 2, number 3.
Thank you, Judge.
This is Alma Alicia Salas Vasquez versus Anthony Bouvier. Cause number 2018 FLI 1884C3. Court marks Mr. Knudsen present and Ms. Saldana present by video conference. Good afternoon to both.
Yes, Judge. We've been conferring,
Give me 1 second. Court marks Ms. Catherine Garcia present and participating by video conference. Just for purposes of the record, unmute your device and tell the court, are you Alma Alicia Salas Vasquez?
He's a Spanish speaker, by the way.
We'll begin language interpretation now. Are you Alma Alicia Salas Vasquez?
¿Es usted
Sí.
Alma Alicia Salas Vázquez? Yes.
Sí.
Welcome to court. The court marks you present. You're participating by video conference.
Bienvenida al juzgado. El juzgado la va a marcar presente por medio de videoconferencia.
Speak into the microphone and tell the court, are you Anthony Bouvier?
¿Usted,
Yes, Judge.
¿Es usted Antonio Bouvier?
Yes, I am.
Sí, señor.
Welcome to court. The court marks you present in person.
El bienvenido al juzgado. El juzgado lo marca presente.
The person to your left is your lawyer.
La persona a su izquierda es su abogado.
Yes.
Ms. Catherine Garcia is present by video conference.
La señora Catherine García está presente por medio de videoconferencia.
Counsel.
And thank you, Judge. I have an announcement. I need to go to JP Court for like 10 minutes. I'll be right back. On a peace bond matter, I think it's gonna get a new date. Because I'm not sure if the defendant was served or just got served and needs more time. That's my understanding from the clerk. So I'm gonna make that announcement. We've conferred. Because we did file a motion to the court to interview the child in chambers.
Let me hear a translation, please.
Les voy a solicitar y necesito ir con el juez de paz. Creo que me va a tardar unos 10 minutos. Creo que se hizo la solicitud de que el juzgado entrevistara al hijo menor.
Yes, and so we've been conferring, we'll see if we can reach an agreement. The child gets out like in 6 minutes and he's gonna have his sister pick him up and bring him to the court. I don't know if the court has time to meet with him today, but I
Let me
think-
hear a translation.
El hijo sale más o menos en 6 minutos, sale de la escuela. La hermana del señor va a traerla. No sé si el juzgado tenga tiempo de entrevistarlo el día de hoy.
At least that way he's old enough, he's a little over 11 and a half years old. And that way the court, I feel comfortable with the court talking to the child in chambers. And just.
Translation, please.
Me siento como el menor tiene 11 años y medio. Me siento cómodo suficiente para que el juzgado hable con el menor.
And that's it. So hopefully we'll continue to confer, have an agreement. And if we do, we'll advise the court. If
Vamos a
not,
seguir
then we'll wait for-
hablando, a ver, ojalá lleguemos a un acuerdo y si llegamos a un acuerdo le notificaremos al juzgado.
First question to Ms. Saldana. Any objection to the court interviewing as standard practice in this court, the child, the day of the final hearing, June the 4th at 1 p.m.?
I would just need to
Una
be,
pregunta para mi Saldaña. ¿Hay alguna objeción para que el juzgado entreviste al menor en junio?
I would like to get that confirmation from my client. We are still in the process of conferring, so I could answer that after, because the child is under 12 and is autistic.
Tendría que hablar con mi clienta porque el niño es menor de 12 años y es autista.
Ms. Flores, this request for an interview comes with a fee on it. Give me a setting in 2 to 4 weeks.
Flores, deme una fecha de 2 a 3 a 4 semanas.
Thank you, Judge.
May 5th at 2 p.m.
Mayo 5 a las 2 p.m.
Thank you, Aaron.
Gracias.
May the 5th at 2 p.m. Mr. Knotson, Ms. Saldana, without holding you to it, what are without telling me specifics, just what are the issues that Ms. Salas and Mr. Bibi have not yet agreed on?
Sin ir mucho en específico, no, señora Saldaña y señor Alonso, denme una idea de cuáles son los temas que no han llegado a un acuerdo entre el señor Salas y la señora Salas y el señor Julián.
I think the issues just temporarily is because, what we were conferring on to see if we could, number one, she could have maybe an overnight this weekend and then come back, maybe do.
Uno de los temas principales era, ya que estábamos hablando, era si el número uno era si ella podría tener una visita y pasar la noche.
And then maybe do an informal mediation with Judge Leticia Martinez in like 2 weeks or before that May 5th date you gave us.
Y luego a lo mejor era tener una reunión informal ya sea con la juez Leticia Martínez, ya sea antes de esa fecha de mayo 5.
So, and I'm not sure if she's conferred with her client, but if we have that agreement, I would recommend that to my client.
Y no sé si ella ha hablado con su clienta, pero si podríamos llegar a ese acuerdo, yo lo hablaría con mi cliente.
And so that's basically from my perspective. I don't know if Ms. Saldaña has
Translation.
anything else.
Y ese es básicamente mi punto de vista. No sé si la señora Saldaña tenga algo más.
Responses to those issues, Ms. Saldana?
So since we're discussing what we're trying to settle here, my client, would request as well the informal mediation with Judge Leti Martinez. Also requesting the same as Mr. Knotson, the sooner the better, 1 week, 2 weeks, whatever time Miss Judge Martinez is available, the court could schedule us for that. And we are discussing.
Translation, please.
Estaría de acuerdo en pedir una mediación con la juez Leti Martínez. Como dijo el señor Knotson, no si necesitamos 2 o 3 semanas.
But we're also asking that the mom be allowed to visit with child, to have the child Friday after school till Monday when school starts every weekend until the mediation.
Y también está pidiendo que la mamá tuviera al menor el viernes después de la escuela hasta el lunes cuando empezara la escuela. De aquí que se haga la mediación.
And that the restriction from mom to have access to this child, to have information from the school be removed so that mom can have access about the child from the school as she used to before this case started.
Y que se le quitara la restricción que tiene la madre para recibir información del menor en la escuela, así como estaba anteriormente.
Both parties are asking for custody, but for this point in time, we're willing to make that offer so that we can work towards hopefully some sort of settlement.
Los dos padres están pidiendo custodia del menor, pero en este momento es que podríamos llegar al acuerdo.
Let me see if I can accurately recite the procedural history in this case so that I can ask you further questions to both.
Yes, Your Honor.
Déjenme ver si les puedo recordar el procedimiento que ha habido en este caso para hacerle unas preguntas.
Judge Ellison heard this case in March, and based on whatever was pled, argued, and or proven, limited the visitations with Ms. Salas Vasquez.
El juez Ellison escuchó este caso en marzo y por cualquier razón que haya sido en ese momento, él puso un límite en las visitas.
Is this true thus far, Mr. Knotson?
Yes, Your Honor.
¿Hasta ahorita es correcto, señor Knotson? Sí.
Is this true and correct thus far, Ms. Saldana?
Señor Saldaña, ¿cierto y correcto?
I was not aware of that. I was retained after that. I didn't know that it went before Judge Ellison.
Yo no sabía, yo entré después de eso, no sabía que fue enfrente del juez Ellison.
Do you have any reason to disbelieve, disprove, or argue those set of facts as told by the judge now in court?
¿Usted tiene alguna razón para decir que no son ciertos los hechos que acaba de decir el juez en el juzgado?
Yes, because my client is, there's nothing that would have warranted my client to not have custody of the child.
Sí, porque en ese momento mi cliente no tenía la patria procesal del menor.
How would you know that if you weren't at the hearing?
Because
¿Cómo sabría usted si no estaba en la audiencia?
Because I know that there was no danger imposed by my client, and the only way to change custody.
Translation?
Porque yo sé que en mi cliente no había ningún peligro para el menor de parte de mi cliente.
But you wouldn't know that unless you're a fact witness.
Pero
sorry?
usted hubiera sabido eso.
I'm sorry.
So, without there being any reasonable dispute as to the facts,
Sin haber-
procedural history as stated by the court,
sin no haber ninguna pregunta sobre los hechos que leyó el juzgado,
what the court needs to hear from both sides
lo que el juzgado necesita escuchar de las dos partes
is what good cause, reason, basis, information, evidence, or facts exists to change Judge Ellison's orders.
lo que el juzgado necesita ver es qué razonamiento, pensamiento, evidencia o hechos hay para cambiar la decisión del juez Ellison.
Or based on the set of facts that were presented at that time, what was wrong then and we should redo now.
O basado en los hechos que se presentaron en ese momento, qué estaba mal que se deben de rehacer el día de hoy.
So that's the point where we begin. In other words, we just picked off where the court left off from last time.
Y ahí es el momento donde continuamos donde acabó el juzgado la vez pasada.
I'm going to mark this without knowing anything else as the second contested matter.
Voy a marcar como la segunda audiencia.
And I need you, Mr. Knotson, and Miss Aldana, to confer reasonably with each other and see what is in the best interest of this child.
Necesito que usted, señor Knotson y señora Saldaña, hablen y vean cuál es el mejor solución para este menor.
Focus on that exclusively. Don't worry about the informal or anything else. If you can get that far, I think you're ahead.
Tengan enfoque en eso, no se preocupen por lo informal.
Anything to add, Ms. Garcia?
Saldaña.
Ms.
Oh.
Garcia?
¿Algo más?
No, Your Honor, nothing to add from the state.
No, señoría, nada de parte del Estado.
All right, so there's only one contested matter before this case. Anything else to put on the record before we recall the case, Mr. Knotson?
No, Judge.
Nomás hay una audiencia anterior a la de ustedes. ¿Algo más que quiera
Oh.
poner en la acta, señor Knotson?
Well, I forgot, they're just, it's not important now, but I know that the teachers are making the child feel very, very uncomfortable, where they're asking the child, oh, what does your father do? Does he walk you to school? Like, they're getting this information from the mom to cross-examine, like, the child about the facts of this case, and that's not appropriate, Judge, and
No.
especially since he's autistic.
Lo único es que los maestros están haciendo un poco sentir incómodo al menor porque le están preguntando qué hace el papá, qué hace tu papá, si lo lleva a la escuela, lo camina a la escuela, y creo que es una situación que no está correcta.
Two to three questions. First question, one, are the teachers parties to this case? Two,
Número uno, los maestros son parte de este caso.
what procedural remedy is there to address that concern?
Número dos, ¿qué reglas de procedimiento hay para llamar la atención a ese problema?
And three, what should the court do?
Y número tres, ¿qué es lo que debe hacer el juzgado?
Well, I think we can, and I'll confer with her on this, and I'll send her copies of the handwritten statements, but I think we can just agree that the teachers are not to discuss directly or indirectly anything about this case with the child. It's not fair to the child.
Le voy a mostrar ahorita que hablemos, le voy a enseñar las notas que tengo aquí por escrito, y creo que las maestras no deben de hablar con el menor directamente o indirectamente
One
sobre
additional,
este caso.
one additional thing to confer on, Ms. Aldana, anything to add?
Otra cosa más de la que deben de hablar, otra cosa, algo más que quiera agregar, señora Saldaña.
I'm just curious how that could be ordered on a teacher who's not, or teachers who are not a party to the case. I mean, that's just my question.
Mi única pregunta es cómo lo ordenaría, cómo se le haría la orden a los maestros si es que no son parte de este caso.
That was my question. It wasn't answered. Rather, Mr. Knotson said he would confer with you on that.
Esa fue mi pregunta y el señor Alonso mencionó que va a hablar con usted sobre eso.
All right, I'll call this case momentarily. Good luck to all.
En un momento le vuelvo a hablar.
Thank
Buena
you.
suerte a todos.
May I be excused, Judge?
Yes, sir.
I'll be back in 30 minutes.
Next case, Attorney Francisco Tamez, page 1, number 1.
Rogelio Saucedo Jr. versus Nalia Guerra Ernesto Guerra, cause number 2016, CVG 1382C3. Court marks Mr. Tamez, present in person, Ms. Aldana, present by video conference. Good afternoon to both.
Good afternoon.
Speak into the microphone and tell the court, are you Rogelio Saucedo Jr.?
Yes, sir.
Welcome to court, Mr. Saucedo Jr. The court marks you present in person. The person to your left is your lawyer. Speak into your device and tell the court, are you Nalia Guerra?
Yes.
Welcome to court, Ms. Guerra. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present by video conference. Are you Ernesto Guerra?
Yes.
Welcome to court, Mr. Guerra. The court marks you present by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Ms. Garcia, at the last hearing, I think you or someone on behalf of your office announced that the Attorney General's office was not participating in this legal proceeding. Has anything changed?
No, Your Honor, that's correct. We are not participating in this case. We do have a child support enforcement case pending in master court right now, but we're not going to appear in this case.
Understood. Thank you, Ms. Garcia. Mr. Tames, Ms. Aldana, many motions to consider. What is the announcement?
Your Honor, we have a motion to compel and motion for sanctions that the petitioner filed. And we also have a motion to appoint a real property appraiser. That is what we have pending before the court.
I see the enforcement, compel and sanctions and appraiser. I see that. Ms. Aldana.
Yes, Your Honor, I filed a motion to reinstate the special appearance of Mr. Ernesto Guerra and also a motion to reinstate Ms. Nyla Guerra's motion to dismiss the case for lack of jurisdiction. So before going into the motion to compel, I would ask that I be heard on the special appearance, which is the reason why we didn't address the motion, the discovery, which is what I expressed to Mr. Dames's office.
Give me 1 second. Let me see if I understand the last part that you said. You said you didn't move on the motions. Why?
Because we are still pending Mr. Guerra's special appearance. So I didn't want to respond to something and waive.
No, I thought you said something about the master because we were last here whenever that hearing was, and I think that was set, the special appearance and the motion to dismiss, all these things were set, but then by agreement, I think the parties mutually agreed to a master in chancery, and then you all further agreed to Sigifredo Perez, and then I reviewed his report, and that puts us in a different situation. What about that is incorrect, Ms. Aldana?
It is incorrect that we did not agree. My clients and I did not agree to the master in chancery. In fact, we had a hearing where the court ordered that a master in chancery be appointed and file reports. And so that was not an agreement. The other issue that was not an agreement was Mr. Sigifredo Perez. Because I was objecting to the master in chancery appointment, I did not agree to anyone being appointed. So that was not an agreement. In fact, I filed a response objecting to the master's report, as was allowed in court at that hearing. I was given.
So let's do this. Remind me, Ms. Aldana, when did you make a request for rehearing, or did you send in another fiat for the special appearance and motion to dismiss?
I filed a special appearance order setting hearing a while back, and it was never signed. It was never given a hearing. So I filed a motion to reinstate the special appearance and a separate motion to reinstate the Ms. Nyla Guerra's motion to dismiss.
I'm not sure how they would be reinstated if they were never said or heard, but assuming that that is true, and I don't know that it is. But when did you file those motions to reinstate?
I filed it timely. I filed it 3 days before this hearing. The 3 days was Sunday, however.
Well, no, that is factually incorrect. So timely does not mean 3 days before, because the court needs to send out notice at least 3 days. But that doesn't mean that you mail it in or you hit send on the electronic service, because when you do that, it first goes to the clerk's office, then they process, then they send it upstairs electronically to the coordinator, then they process it, it gets reviewed by her and by our staff attorney, and then gets sent to me. That, on a good day, takes 1 to 2 days. So if you file 3 days before, you're already outside the setting window, because things don't happen by osmosis. So let's do this in the interest of fairness and justice. The motion to dismiss is not set for today. The court will not hear that until we can set it, notice it, set it, and give counsel time to respond. The special appearance is a different animal because those take precedence over all other motions. So Mr. Tamez, what objection, if any, do you have to the court hearing a special appearance?
It's been waived.
Tell the court how and why.
Judge, a special appearance, as you know, is a vehicle that's used procedurally by a party who's denying that the court lacks jurisdiction over it. In this particular case, Mr. Guerra has participated in the litigation of the current proceedings before the court. Mr. Guerra, as we've already discussed, and this is just a delay, he lives in Webb County. Right? The property subject to the suit is in Webb County. And he was served with citation and he has answered. All of those are precursors to a clear waiver of any special appearance, but just the fact that he lives in Webb County, was served in Webb County, the property subject to this enforcement action is in Webb County. I just don't see under the rules of procedure how, with a straight face, counsel can come in here and saying that she's entitled to a special appearance for Mr. Guerra. It's beyond me.
And Ms. Alania, in response, what is your position or argument as to the special appearance and now respond to the waiver argument?
Yes, Your Honor. My client did not waive his special appearance. In addition to the special appearance, my client also filed within that special appearance. He challenged personal jurisdiction. He challenged in rem jurisdiction. He challenged the plea to the he filed a plea to the jurisdiction within that. He requested the court to decline jurisdiction in addition to his original answer. None of that has been heard. We're asking that it be heard. He did not waive it because he was
tell the
saying,
court factually and legally how if true, how is that substantiated? Like what, flesh that out for the court.
yes, Your Honor. So my client is saying that the court did not have, or is requesting that the court decline jurisdiction because in the divorce decree and in the divorce, he was never made a party. Yet the property that is under his name, he's the record owner, it was never brought in. And so rulings were made forcing him to, or ordering him to sign a warranty deed for the property when he was never given due process in that divorce. In addition to that, now the master in chancery is saying that in his opinion, Ms. Naila Guerra and Mr. Salcedo, Rogelio Salcedo, are equitable title owners. However, in order for that, for anyone to come to that conclusion, the title owner must have been included in that original hearing, that divorce hearing, and he wasn't. And I cited in my response all the reasons why, all the statutes that support that he should have been made a party to that case. So because he was not made a party, then I'm asking the court to decline jurisdiction because he wasn't given the due process.
Reply to that response, Mr. Tamez?
He was served. What happened in the
He was
allegation-
served when and where or how? Into the record?
He was served in this proceeding, Judge, for enforcement.
Well, so in response, Mr. Tamez says that he was served here. Let me ask you all this, because I spent some time in the history of this case, and the reason it really now sticks out in my mind is because Mr. Salcedo is moving to enforce a decree that the court signed in May of 2017. Now, that time period is fairly memorable to the court because this court had been on the bench for 1 month. So in what would happen at that juncture, if I recall correctly, based on my memory and reviewing the docket, is that two other lawyers, unless I'm mistaken, two other lawyers announced an agreement between Mr. Salcedo and Ms. Guerra, and the court signed that final decree of divorce by agreement. Now, I read that agreement. I went back, May 2017. And in that final decree of divorce, what that decree says is that Mr. Salcedo and Ms. Guerra are to divide this property equally, being co-owners or the marital property, one have each. Does that sound about right, Ms. Aldana?
Not entirely, because it did not in the divorce decree ever state that that property was community property. In fact, it didn't say that they were owners of the property.
But anything silent is inferred. In other words, you have a duty, Ms. Guerra has a duty, Mr. Tamez has a duty, Ms. Salcedo. Every person before the court has a duty to disclose anything that should be known. So that at the time that the court enters in a division order for 1/2 each, that would have been the best time to tell the court, by the way, there's other persons that own this property.
Yes.
Is that not the case?
You are absolutely correct, Your Honor. That is exactly
So
the
if
time
that's
that-
true, and Ms. Guerra would have known, having been a signatory to the final decree of divorce, wouldn't that have been the right time to tell the court, by the way, my father owns a portion of this property?
Yes. And
Was
that is
that ever disclosed to the court during that time period?
from the record, no, that I've seen, no. And that's why Mr. Ernesto Guerra was denied his due process. So
Well,
these
he
two
was
parties,
denied his due process, not because of anything the court did or the other side did, but because of an undisclosed factual piece of relevant information by Ms. Guerra, no?
Texas Code 9.401, lack of jurisdiction. A decree of divorce is void if the court rendering the decree lacked jurisdiction at the time of the decree was rendered. Now, I know that Ms. Naila Guerra.
Say that again, flesh that out. You cited a point of law. Tell the court how that applies to this case.
Because Mr. Salcedo was not a husband or a wife or any other party to this divorce decree. Mr.
Mr.
Salcedo,
Salcedo wasn't?
I'm sorry, my client, Mr. Ernesto Guerra. Mr. Ernesto Guerra was not a party to the divorce. So because he was not a party to the divorce, husband and wife can't say, we're equitable title owners, but we're gonna leave out
But that
title.
is in fact what happened.
That is in fact what happened, and that's exactly why that order is void. At least the order regarding the real property.
Your Honor, last time I
But
checked.
in order to be void, I guess to the court's point, why didn't someone here, and I would presume that the best person to have that information would be Ms. Guerra. How was that important, relevant, if true, piece of factual information not disclosed to the court, either on the record or made a part of the final decree of divorce? How did that happen?
So it would have been Mr. Salcedo and Ms. Guerra who should have said, we're not the title owners. And the lawyers maybe could have looked up the deed history, to see who is actually on the deed. The problem remains that Texas Rule of Civil Procedure 39, joinder of persons needed for an adjudication. Mr. Guerra should have been included in that conversation. He should have been given notice and due process so that he could defend his title interest, his record interest to that property, which was not community property.
I understand. Anything in response, Mr. Tamez?
Your Honor, last time I checked, Mr. Guerra was not married to Mr. Salcedo, and so it wouldn't void the decree. What counsel is arguing, if true, then her client, where I think she has a very serious conflict between father and daughter. If true, the daughter has committed a fraud to the court because she under oath in the prove up of the divorce agreed that the property would be divided 1/2 between my client and herself. As the court accurately pointed out, that duty to, and she was represented by an attorney. Both parties were. Both parties blessed the divorce decree that was signed by the court. And so if that's the case, if we want to undo everything that the court has already done about 10 years ago, then Ms. Saldaña's client has committed and perpetrated a knowing fraud. Notwithstanding, to address the issue of this mysterious special appearance, Judge, the court's own document shows that the client was served.
Inaudible.
For the record.
On March 2025. So the Mr. Guerra is before the court. He is a resident of Webb County. And we're here to address these issues because the divorce decree, up to now, my client hasn't received any interest pursuant to the decree. He hasn't received any of the information that decree orders that he be provided. He has not seen any proceeds from any rental. He has just barely, through a lot of struggle, started to receive some of the statements relevant to this property. So to say that, let's parse this out, the special appearance, he is here. He has been served, he is before the court. And he is a resident of this county. So I don't know how a special appearance rectifies that fact.
Like I said, it wasn't just a special appearance, but in addition to that, if Miss Naila Guerra is guilty of fraud, then so is Mr. Saucedo, because he was here and he should have known the history, what the condition of the property he claimed was his.
Well, he did. And
So
he-
if Mrs. Guerra is guilty
So
of
let
it,
me ask some questions. And if I missed a pleading, Ms. Aldana or Mr. Tames, you need to remind me, but Ms. Aldana, let's assume that I agree with you in the first instance as to service or notice in the divorce decree. And I don't know that we get there because that is finalized, but there is no question that Mr. Guerra has been served now, and at least since March 2025. Let's assume that the court would grant, and I don't know why it would, but let's assume that the court would grant a special appearance and the dismissal of this claim. Is there any pleading or prayer for relief that would undo the final decree of divorce of May 2017?
Miss Naila Guerra's motion to dismiss for lack of jurisdiction. And it
That
was,
dismisses this claim, but it does not undo the final decree of divorce.
so if I
So
may
one
explain,
more time, is there any procedural vehicle request for relief or pleading that either clarifies, undoes, or asks for something that modifies the final decree of divorce?
yes, Your Honor.
Tell the court what that is.
That is specifically modifying only about Mr. Ernesto Guerra and anything in connection to the real property, not the entire.
What is the pleading and what is the procedural vehicle?
Again, I know that you responded something about Ms. Naila Guerra's, but in Ms. Naila Guerra's motion to dismiss, we're also alleging that there's no jurisdiction because of the lack of due process. So,
Let's assume that's right, and I don't know that it is. Here's the question that the court has. Let's assume you're right. You win. There's a valid and enforceable final decree of divorce that says the parties need to dispose of this property in this manner. Is there anything in the record that has been pled for relief or any cause of action that modifies, undoes, or rehears or clarifies the final decree of divorce?
yes, Your Honor.
Tell the court what that is.
And that is, I repeatedly filed documents about that. It was Mr. Guerra's special appearance, his personal jurisdiction and in rem jurisdiction, the plea to the jurisdiction, the request for the court to decline jurisdiction. I also added it in the motion, the respondent's response to an objection to the report of master chancery, where I cite the Texas Rule of Civil Procedure 39, the joinder of persons needed to be adjudicated, the Texas Constitution, which I cited in my special appearance in rem jurisdiction and in the motion to dismiss, that no citizen of the state shall be deprived of their property in any manner without the due course of law in the land. There's the Texas Rule of Civil Procedure, Rule 124, no judgment without service. In no case shall judgment be rendered against any defendant unless upon service or acceptance or waiver of process. He was ordered by the court, by the divorce decree, to sign a special warranty deed because clearly Mr. Saucedo and Ms. Guerra did not have ownership. In fact, it was not fraud because it was disclosed, and that's exactly why Mr. Guerra was ordered to sign that special warranty deed. Additionally, I also wrote in here that I filed with the court, the Texas Family Code 9.401, lack of jurisdiction, a decree of divorce again, is void if the court rendering decree lacked the jurisdiction at the time. I'm not saying the entire divorce decree is void. All I'm referring to is Ernesto Guerra's portion of it, which is the real property and his person.
The court hereby takes judicial notice of the entire case file. The court makes the following findings at this juncture. The court finds that there is no pleading or request for relief that clarifies, modifies, or changes a valid and enforceable final decree of divorce. 1. 2, the court thereby finds that the service effectuated on March of 2025 makes the special appearance moot. And therefore, for all of these reasons, the remaining motions to dismiss and so forth are hereby respectfully denied. Let's move on to the enforcement, compel, sanctions, and the appointment of a real property appraiser. Ostensibly, Mr. Tames and Ms. Aldana, ostensibly, there isn't an agreement, is there?
Well, Your Honor, we were set for mediation. I don't know if that's still something that we were gonna do or not. I don't know.
No, Your Honor, I'm ready to go on my motions, and just for the clarification of the court's ruling, I misspoke earlier. Ernesto Guerra was served on July 29th, 2025, and the return of service is dated July 30th of 2025. My apologies.
So noted on the record that the date itself doesn't change the findings of the court. There is a valid and enforceable final decree of divorce, and there is no, in plain English, there's no card on the table that allows the court to modify that decree in any form. It's valid and enforceable, and there you go. And then on the subsequent enforcement action, there's service, so on we go. Folks, this is now the third contested matter on the court's docket. Talk to each other, see if you can come to a good place. Anything that you don't agree to, I will make a decision for you. Mr. Saucedo, Mr. Guerra, and Ms. Guerra, talk to your lawyers. I wish you best luck shortly. Good luck.
Next case, Your Honor, online. Attorney Elisa Marsoto, page 3, number 6.
This is Irma Ramirez versus Ismael Ramirez Jr., cause number 2025 FLA 929C3. Court marks Ms. Soto present by video conference. Good afternoon.
Afternoon, Your Honor.
Are you Ismael Ramirez Jr.?
Good afternoon, Judge. Yes, Ismael Ramirez Jr.
Welcome to court, sir. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Madeline Lopez Escoto, Irma Ramirez, Leticia Garcia. Any other person present?
I am present. Good afternoon, Judge. Nice to see you. And so is Ms. Ramirez.
Welcome to court. Good to see you, Mrs. Escoto. Court marks you present and participating by video conference. Are you Irma Ramirez?
Yes, Your Honor.
Welcome to court, Ms. Ramirez. Court marks you present. You are participating by video conference, as is your lawyer. Good to see you as well, Ms. Garcia.
Good afternoon, Judge.
Court marks you present by video conference. Counsel, go ahead.
Judge, on this particular case, we have received Ms. Garcia's ad litem recommendations. Pursuant to the same, settlement offers have been exchanged back and forth. In fact, I received Ms. Soto's counter this morning. We have not reached an agreement, regrettably, but we have agreed to the following. Number one, that we will attend mediation with Marta Cigarroa, if it pleases the court, and the parties will pay the fees 50-50. We have agreed to list the residence located at 505 Valnera, Valnera Drive, with a, I'm assuming, Ms. Soto, with a realtor appointed by the court?
Correct.
Okay, by a realtor appointed by the court, and sign the listing agreement on or before Friday, April 24th of 2026. The property will be sold as is, All major appliances will be sold with the house except the washer and dryer. The parties have agreed to list the residence at an agreed upon price, but no fair market value. Both parties will cooperate with the realtor showings and inspections and sale at all times. A block box will be installed for ease of showings. Both parties will have access to the residence and shall coordinate with the realtor appointed by the court for the removal of the items that will be awarded to each party herein. Mr. Ramirez will tender the mailbox key to Ms. Ramirez, who shall then turn the same over to the realtor. The parties have agreed that until the residence is sold, they will each pay beginning May 1st, the 50% each of the monthly mortgage, taxes, insurance, utilities, maintenance until sold. The parties have agreed that Ms. Ramirez will be allowed to remove the following items from the house: a washer and a dryer, the master bedroom set and bed, the brown sofa / kids bed in the master bedroom, the curio cabinet and context, except for the Last Supper sculpture and paternal grandfather's cap, that's been awarded to Mr. Ramirez. The parties have agreed to split the pictures, albums, and wedding gifts half, or at least the photos on the albums of the pictures of the family. The children's beds, the bedroom sets, the lamps, chairs, sewing machine, and craft supplies. Ms. Ramirez will also be awarded the kitchen pots, pans, small electrical appliance, and kitchenware, except for the plates gifted by El Profesor and boxed wedding kitchen items that are going to Mr. Ramirez. Ms. Ramirez will be allowed to remove the living room TV and wall mount, the printer stand, the children's belongings and toys, the freezer in the garage, the metal shelves in the garage, the home decorations, holiday decorations and artwork, a jewelry stand in the garage, storage bins in the garage, Catholic artifacts, and any other agreed upon items. Did I miss anything, Ms. Soto?
No, looking at my list, that was correct.
Okay, and we will submit to the court an agreed order appointing Ms. Cigarroa judge. And then we will await the court's order appointing the realtor as soon as possible, Judge.
And
I think the court has a blank order on mediation. I've signed it and written in Ms. Figueroa's name unless there's an objection.
No,
No, Your Honor. But I thought Ms. Escoto was asking me about the list of items. There were just 2 revisions, Judge. He's willing to turn over the mailbox key to Mrs. Ramirez if she's picking up the mail. He just asked that she's agreed that his mail addressed to him, because he's no longer living on the premises, be provided to his mother.
That is correct, Judge. We will do that.
Yes, and then on the access to the property, he's okay with both of them having access to the property. He just asked that if things are going to be removed, that both of them do it at the same time, and he's willing to assist her with that moving process.
And that's just logistically impossible, Judge. He's living in San Antonio. My client's here. And so she would like to start removing the items that have been awarded to her, possibly by this weekend. Just because they need to clean this house. This house has been vacant, or at least no one has lived in this house since sometime last year. And I can only imagine the condition that it is in. And so she'd like to start removing her things so that the realtor can go in there and start taking pictures and listing it with the MLS. Because at this point, no one's living in that house. And so she'd like the opportunity to go start removing her stuff and not be hostage till whenever he comes to Laredo, so that they can both be at the house. And this is just one of those highly contested cases, Judge, that is probably not in the best interest that they both be at, and his mom can be there. We don't have an objection to his mom being there if she wants to be there while she's removing his stuff, because his mom lives here.
And Judge, so he was planning on being here this weekend, so as long as there's no objection with him also retrieving his personal belongings this weekend in the presence of his mother, along with Ms. Ramirez, I think that my client would be okay with that.
Ms. Ramirez, is that okay with you?
For this weekend?
Yes, to start removing all the items.
Yes, we could start this weekend.
Well, Ms. Ramirez, Mr. Ramirez, I know that you have other things that are unresolved, but this is a very, very long list of agreements, and that means that there has been a lot of good work, diligence, and communication. You haven't gotten to the finish line yet, but you're well on your way. Same comments to you, Ms. Soto and Mrs. Cotto. That is a very long list of agreements. Ostensibly, what are the issues, and don't go into specific, they're just banner issues that Ms. Cigarroa can assist the parties with?
So this, the offer that was sent, Judge, was a 7-page offer. Given the recommendations from Ms. Garcia that I sent to Ms. Soto. And so the issues are, number one, the supervised visits by Mr. Ramirez and the children. Whether
All right.
day visits, overnight visits, and then there's also issues having to deal with the division of the community estate.
All right.
That's
Ms.,
correct, Ron.
anything to add, Ms. Garcia?
Nothing, Judge.
All right, Ms. Flores, give us a setting in, well, you tell me, Ms. Soto, Mrs. Cotto, how much time would be reasonable? 30, 60, more, less?
I would say, Judge, in less than 30 days, we just really need to resolve this case, especially before the kids get out of school.
And we
Ms.
did
Soto?
confer, Judge, that's correct. We want to make sure that at least we can get a date within the next 2 weeks with Ms. Cigarroa to try to dispose of this case for the parties sooner than later.
Sure. Ms. Flores, give us a setting before the end of May if possible. What dates do we have?
Do you have May the 5th, Your Honor, available?
Is
May-
that's so short. I'm concerned about all of the lawyers' schedules.
I can do May 5th. I don't know about Miss.
I'm available, Judge, but I have a, so that I haven't contacted Ms. Cigarroa. I don't know if she's gonna be able to see us.
Okay.
That's my
So,
concern.
yeah.
How do we look on the 19th?
We have 20 cases, Your Honor.
I tell you what, let me give you the 19th.
Yeah.
But knowing that you're gonna push us into contested late, if it isn't. But hopefully everybody here will have some time to visit with Ms. Cigarroa before then. So let's all hold our breath, shall we? May the 19th at 2 p.m. So I'm gonna write in that into Ms. Cigarroa's orders. It needs to be completed before May the 18th. All right, so I'm tendering that order. I'm going to ask Ms. Soto or Ms. Escoto, one of you please file that agreed to order on the listing, leave a blank. I'll fill the rest in. I'll sign it as soon as it comes in. Ms. Ramirez, Mr. Ramirez, you'll visit with Ms. Cigarroa before May the 18th, and you'll come to court and announce an announcement, a full agreement, or you'll be placed under oath to tell the court under oath what you're asking for and what supports that position on May the 19th. Ms. Ramirez, do you have any questions for the court?
Oh, Your Honor.
Mr. Ramirez, do you have any questions for the court?
Nothing, Your Honor.
I usually tell folks to keep in contact with your lawyers, but you've done a lot of communication, so I certainly commend you for that. Continue to remain in contact with your lawyers. I look forward to seeing you on May the 19th. Good luck to all.
Thank you, Judge, and thank you to Ms. Garcia for assisting the parties, Judge.
Amen.
Thank you, Judge. Thank you, Ms. Garcia.
Thank you.
Next case, Your Honor. We're going to recall page 4, number 10, Attorney Villafranca and Attorney.
Mario Alberto Valdez, Jocelyn Ventura, cause number 2025 FLI 276C3. Court marks Mr. Castillo present in person, Mr. Villafranca present in person, Catherine Garcia present by video conference, Mario Alberto Valadez Jr. present in person, and Jocelyn Ventura present in person. All persons present. Council, go ahead.
Your Honor, if you may, we do have an agreement on one of the issues. There's two. One is custody and visitation, and then the other one was child support filed by the Attorney General's office, Your Honor. The only thing we wanted to do with the child support case shows is that we found out that opposing party has a new job. I just need to look at his pay stubs, Judge. So we'd like to revisit that issue in 30 days. Plus, I'd like to have a conversation with I'd like to have a conversation with the Attorney General's office because we don't know. I guess it's their petition, Judge, but I need to know what the arrears would be because it looks like there would be some credit given. So I'd like a little opportunity to talk to the Attorney General's office.
Response, Mr. Castillo?
That's correct, Judge. It's pretty much summarizes what we confirmed.
Who from the Attorney General's office is handling the case, Your Honor?
I don't know. Ms. Garcia, do you know?
I'm sorry, I didn't hear the question.
Who from your office is handling the case?
It's not assigned to one particular person, but I'm here today for the state.
I'll contact her, Judge. I have her email address. I'll contact her as soon as possible.
Who here would like to tell the court what the agreement is with regard to visitation?
It's basically standard, Judge. First, third, fifth weekend of every month, starting Friday, ending Sunday. Friday after school.
So the agreement is standard visitation for Mr. Valadez with the exclusive right to designate for Ms. Ventura?
That is correct, Your Honor. Joint management conservatorship with Ms. Ventura determine the primary residence of the child.
Mr. Valdez, Ms. Ventura, would you raise your right hands? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, Your Honor.
Both have answered yes. You may lower your hands. Is your true and correct name Mario Alberto Valadez Jr.?
Yes, Your Honor.
Mr. Valadez, you're joining us in person. Your lawyers to your left. Mr. Valadez, did you hear, understand the agreement that was told to the court by the lawyers regarding your children?
Yes, Your Honor.
Is that your agreement with Ms. Ventura?
Yes, Your Honor.
Is that your full agreement regarding your children?
Yes, Your Honor.
Was anything left out?
No, Your Honor.
Is there anything you want to change?
No, Your Honor.
Do you believe that this agreement is in their best interest?
Yes, Your Honor.
Same questions for you, Ms. Ventura. Is your true and correct name Jocelyn Ventura?
Yeah.
You're joining us in person. Your lawyer is on your right. Ms. Ventura, did you hear the agreement that was told to the court by the lawyers? Is that your agreement with Mr. Valadez regarding your children? Yeah. Do you believe that was that your full agreement? Was anything left out? Is there anything you want to change? Do you believe that this agreement is in their best interest? Yeah. Court hereby adopts and approves the agreement, finds that it is in the children's best interest. The court hereby appoints both parties joint managing conservators with Ms. Ventura given the exclusive right to designate the residents. Mr. Ventura will have standard visitation per the Texas Family Code. These are the orders with regard to that issue. These orders are due to the court on or before
May the 18th at noon by submission.
I'll sign them as soon as they come in. So you sign them, you send them in tomorrow. I'll sign them tomorrow or the next day. Welcome back for the hearing on child support on.
How much time, Your Honor?
Give us the next available, whatever date we have less than 21 cases. 18 cases.
June the 2nd, Your Honor. At 2 p.m.
So just keep in mind, Mr. Valadez, you have under Texas law the duty to supplement any information. So the more time that goes by, the more information that your lawyer needs to send Mr. Villafranca information on wages, pay stubs, tax returns, whatever the case is, because this court, as all courts do, needs to order a true and correct calculation of child support. Whatever that number is, it just needs to be true and correct. So the more information that you give your lawyer, the more information that's going to allow the court to make that calculation. Do you have any questions for the court, Mr. Valadez?
No, Your Honor.
Do you have any questions for the court, Ms. Ventura?
No.
Anything else, Mr. Castillo?
Nothing further, Judge.
Mr. Villafranca?
No, Your Honor.
Ms. Garcia?
Nothing further, Your Honor.
Ms. Ventura, Mr. Valadez, I wish you both very well. Have a good day.
Thank you, Your Honor.
Thank you.
Good to see you both. Yes, have a
Thank
great
you,
day.
Judge.
Next case, Attorney Madeline Lopez Escoto, page one, number 2.
Galdina de los Santos versus Eduardo de los Santos, cause number 2018 FLA 500C3. Court marks Mrs. Scotto present by video conference. Mr. Martinez King also present by video conference. Ms. Catherine Garcia is also present, and she's also here by video conference. Good afternoon to all.
Good afternoon again, Judge Madeline Escoto for Mr. De Los Santos, and he is not present.
Court marks Mr. de los Santos not present. Galinda de los Santos, are you present? Court.
Good afternoon, Judge Albert Martinez King on behalf of the Galdina de los Santos. She's not present either.
Court finds neither party present. Counsel, what is the announcement?
Judge, we filed an agreed motion for continuance. We have exchanged bank statements as we had announced at the last court hearing. There have been material and substantial changes as one of the children that was living with Ms. De Los Santos has also now gone to live with my client. Mr. King and I conferred last night. He needs time to also give me additional information as the parties are disputing cohabitation credits and possibly possession credits. So we've also conferred in the hopes of trying to finalize this case, as if the court remembers, Ms. De Los Santos is disabled, that the court would entertain the parties going to mediation with Judge Leticia Martinez in the hopes that we can resolve this case in its entirety, given the change of circumstances that Cassandra now has gone to live with my client. And those are the requests from Mr. King and I today.
Mr. King?
That is correct, Judge.
Ms. Garcia? Ms. Catherine Garcia?
She froze.
No, she's on. Ms. Catherine
You're
Garcia, anything to add?
having technicalities here. My in and out. I'm not opposed to a continuance if you can hear me.
Mrs. Scotto, Mr. King, any objection to May the 11th with Associate Judge Martinez? At 1:30.
Judge, I have the 341st starting at 1:30, and I have 1, 2, 3, 4 cases.
What is wrong with my computer?
Ms. Scotto, Mr. Martinez King, any objections to April 27th,
In the afternoon, Judge?
1:30?
That should be fine, Judge.
Mr. Martinez King?
Give me one quick second. I will actually be out that day. No, you know what? Yeah, I can make it work. I have a way to move it around. We can make it work. Are you guys able to hear me?
Yes.
Yes, I am pulling up her calendar so that I block it off right now.
At 1:30, correct, Judge?
Yes, ma'am. Ms. Flores, the court has ordered the parties to mediation April 27th. Give us the next setting for a final hearing, please.
May fifth at 2 p.m.
All right, anything else on this case, Mr. Martinez King, Mrs. Soto?
I'm sorry, what date did she say?
May the 5th at 2 p.m.
And did you say the mediation date was May 27th?
April.
Oh, I'm sorry. I apologize. I thought
I
I
moved it.
heard.
I moved it earlier because if I move it later, you're looking at June.
Okay, I do have cases here, but I'll ask Miss, and then they're all, they're all entry of orders, so that's perfect for me as well, Judge. I
No,
apologize. I misheard.
no worries. So just for the record, one more time, mediation with Associate Judge Martinez, April 27th at 1:30. Final hearing on this case, May the 5th at 2 p.m. Mrs. Cotto, anything else?
Nothing further, Judge.
Mr. King?
Not on our end. Thank you, Judge.
All right, thank you both.
Next case from Mrs. Cotto, page 3, number 8.
This is Carlos Eduardo Guerra versus Karina Gabriela Mendoza, cause number 2025 FLA 1452C3. Court marks Mrs. Cotto present by video conference. Attorney George Outfield or parties Carlos Guerra, Karina Mendoza. Any other person present?
No one else is present, Judge. I believe Mr. Altgeld is in a federal criminal trial. I am pleased to announce to the court that you've already signed the agreement. And so all we need from the court is an entry of order date. And so I have told Mr. Altgeld that I'll prepare the decree with the affidavits of prove-ups and attach that agreement that has already been signed by the court.
I think you read the court's mind and took the words out of my mouth. But the reason I didn't pre-sign the motion for continuance is because I signed a Rule 11 ostensibly resolving all issues. So there was really nothing to continue.
I think his office just did it out of the abundance of caution. They had not heard from him.
That makes sense to the court. Mrs. Cotto, you're asking for an entry on a docket date or just an orders due date?
Orders due date, Judge.
Right, orders are due on this case on or before.
May 27th, my apologies, April the 27th at noon by submission.
All right, so ordered.
All right. And I think I have two more, Judge.
Page 5, number 14.
Ricardo Gallardo Soto versus Clarissa Yvette Gallardo, cause number 2026 FLA 401C3. Court marks Mrs. Cotto present and participating by video conference. Ricardo Soto, Clarissa Gallardo. Any parties present? Court finds no parties present. Mrs. Cotto, go ahead.
Judge, Mr. Romero and Manuel Flores are opposing counsel in this case. We filed yesterday a continuance as we've exchanged settlement offers for purposes of temporary orders, but have not reached an agreement. If the court read the verified agreed motion for continuance, we have agreed to go with Judge Hale for the temporary orders mediation / possibly a full settlement in this case. And then we've agreed to abide by a temporary mutual injunction as well.
I was just pulling up the case docket. I certainly believe you, but I wanted to verify because I was not aware and now I know why. Neither Mr. Romero nor former Judge Flores have filed into the case. I mean, I'll take your word for it.
He signed the continuance.
I'm here, Your Honor. That's correct.
Okay.
Yes, you did. Page 2. There it is. I did not. I overlooked that. Well taken. All right. The court is signing. Court marks Mr. Romero present and participating by video conference. For all of the reasons stated on the record, the court hereby grants a request. This case is continued. The parties are to mediate with Senior Judge Hale. But I guess we need, so you're coming back for trial on June the 16th. Give us another temporary orders. Well, do you want to go to visit with Judge Hale first, or you want your TO date first?
I think that what we agreed to do was just go to mediation with Judge Hale. If the court maybe wishes to give us, I know that you don't like those status hearing, Judge, but maybe that May 19th date.
Any objection?
For
Any objection?
No, Your Honor.
All right, I don't, but we can do a final pretrial hearing, so anything is filed will get heard on that date. Final pretrial hearing on before 6/16.
Would the May 5th be too soon, Your Honor?
Yes. Do-
May 19th at 2 p.m.
So ordered without objection. All right. I wish all persons well at mediation. Good luck.
Thank you, Judge.
Thank you, Your Honor.
Next case for Mrs. Cotto, page 7, number 18.
Noemí Galeano versus Bernardo Karim Trad, cause number 2026 FLK 402C3. Court marks Mrs. Cotto present and participating by video conference. Speaking to the microphone, unmute your device and tell the court, are you Noemí Galeano? Unmute your device, please.
Yes, Your Honor.
Welcome to court, Ms. Galeano. The court marks you present. You're participating by video conference, as you can see and hear from your device. Your lawyer is also present by video conference. Speaking to the microphone and tell the court, are you Bernardo Karim Trad?
I am, Your Honor.
Welcome to court, Mr. Trad. The court marks you present in person. Mr. Trad, do you have a lawyer?
I do not, Your Honor.
Will you be going,
Inaudible.
speak into the microphone?
I do not have a lawyer, Your Honor.
Right. Will you be going forward without a lawyer, or are you asking time to hire a lawyer?
So, due to recent events of late, I would very much like the opportunity to attempt to hire a lawyer.
Ms. Escoto?
That's fine, Judge. This is just a petition to enter a quadro.
Remind the court, because this is a new filing, Mrs. Scotto, in the original final decree of divorce was a division of retirement ordered in the
Yeah.
final decree?
It has been, Judge, and I uploaded into Caseline. Because I did send Mr. Trad the proposed quadro. He had a change. I made that change. There was another change requested, but I'm not going to remove that particular provision because of what the decree says. But both the original petition to enter the quadro with the Exhibit A, which is the divorce decree,
Yeah.
and the proposed quadro have been submitted into Caseline, and the quadro has been also filed. The proposed quadro has been filed with the
Yeah.
district.
So I just wanted to confirm. So what Ms. Galeano here is requesting is just an entry of an order that conforms to something already granted by the court in the final decree of divorce?
Correct, Judge.
All right, so now the question then to you, Mr. Trad, is knowing, and I'm gonna assume for the sake of argument that everything that Mrs. Cotto has told the court is true and accurate. Knowing that the court has already ordered this to happen, how much time do you believe would be reasonable and necessary to look for a lawyer and hire a lawyer?
So,
Into the microphone.
Due to, I agree completely, the final divorce decree has been signed, and there are very concrete limitations as to the awards, which is what is being contested at this point. At least on my end. I went ahead and tried to contact a lawyer, and the earliest date that they could see me, the even schedule an initial consultation would be May 11th. So I'm asking for whatever time the court sees fit to allow me to be able to hire a lawyer at this for this.
So let me tell you what the court is thinking, so that you know how best to respond. If Mrs. Cotto had said, this is a new petition because I'm asking for something that wasn't ordered, that means some lawyer, whoever you hire, is going to have to do a lot of research and homework and background for this case. Having heard that she's asking for, she's asking for on behalf of her client for something that was already ordered, All the court needs to do is, was it ordered and what needs to happen? And there you go. The amount of work, ostensibly without knowing anything else, that a person needs to do to get up to speed and to present your case and defend your position, whatever it is not this much, but it's much less. So I think a month is not reasonable, but that's why I'm asking you how much time, so that I know. I mean, frankly, I think a week or two is more than sufficient. However, if you have other considerations, financial, time limitations, medical situations, those are the things that I need to hear, because to the court, because it's already ordered, is much more cut and dry than other situations. Knowing that that's what the court is thinking, how much time do you reasonably need, Mr. Trad?
If I get the full 30 days, that would work really well. I agree completely, Your Honor, that the final decree is already ordered. It's already set in stone. Where there's some verbiage in this new quadrant, in this new addendum, that would substantially change the award amount. And that is the part that I would need legal counsel on.
So
It would change. I didn't follow, and I apologize to you, Mr. Trad, but it would change what now, if granted?
So, the whole point is there is a finite amount awarded in the final divorce decree, which was agreed upon and which was what's called mediated and sent over to my lawyer. So I agree completely with the court, Your Honor. There should not be very much here. However, there was a verbiage entered in the addendum that would substantially change that award amount, that final award amount, and that is the part that I'm seeking legal counsel over.
All right, knowing all of these, having heard that response, how much time you believe would be reasonable and necessary, Mrs. Cotto?
Judge, 2 weeks. It shouldn't take as long as that. I'm actually doing this for free for Ms. Galliano. For whatever reason, the quadro was never entered. We did the decree, we did the special warranty deed, and for whatever reason, the quadro wasn't entered. The parties were divorced, judged by this court in 2022. And so this is just a matter of formality. He just does not like one word in there, but I can't give him legal advice. He needs to have an attorney read the whole paragraph so that he understands why that one word is in there.
Ironically, so I'm looking at the court's calendar. Request is 2 weeks, 4 weeks, and we have a setting on May the 5th. So it's not 2, it's not 4, we have 3. So there it is. May the 5th at 2 p.m. Anything else on this case, Mrs. Cotto?
The court should know that there is a modification that has been filed by Mr. Trad set for May 5th. So I'm hopeful that his attorney, Juan Garcia, can also take care of this, as I will be representing Ms. Galliano on that case.
Is that 2021 FLA 1036C3?
That is 2020, I'll tell you right now. 2021 FLA 1036C3.
Do you have a companion case? This is perfect. I wish I would have known that, because that is the best and most ideal situation and setting. All right, Ms. Galeano, do you have any questions for the court?
No, Your Honor.
Mr. Trad, do you have any questions?
I just want to clarify, so that the final date that I have to be able to consult with.
Closer to the mic, please.
Into the microphone.
So I just want to ensure that I understood the time that I do have to be able to confer with the legal counsel for this is on May 5th as well.
No, sir. Your final deadline is probably tomorrow. I mean, so that means your setting is on May the 5th, which means you need to look for a lawyer, talk to a lawyer, and hire a lawyer well before that date. That doesn't mean go out and find someone on the 5th. That means be ready to have your case heard on the 5th. But what Mrs. Cotto just told the court, and I have what my notes say is that there's a companion case and
I did reach out to
the notes. My notes are in there. Thank you, Miss Flores. Your companion case is already set on May the 5th. So on that date, you're going to come in for 2 final hearings. First, on the motion to modify, and now also on this quadro, which quite frankly should work best for all, because you're going to come into court on one day and not one day on one day on the other. So all that to say, don't wait until the 4th or even the week before, but try to get someone as soon as possible.
Understood, Your Honor.
All right.
And just so the court knows, Judge, I did my due diligence. I reached out to his prior attorney in the divorce just to avoid all of this. And that person told me that he was not representing Mr. Tradd. That's why the petition had to be filed.
Yeah, and the other thing you should know to put you at ease, Mr. Tradd, so you really need to hire a lawyer as soon as possible, but you don't have to. The court really, it's going to be almost, I mean, unless you all throw a wrench into, I mean, I haven't seen it, but the court is going to look at the black and white letter of the divorce decree and then just figure out what was ordered and then effectuate its own orders, unless you all come up with some novel.
If that's the case, and I'm sorry, if that's the case, if the court, if you feel that I do not, because it is going to be based off of black and white, then I believe we can proceed with my concerns on that one word as Mrs. Foto Lopez mentioned.
Knowing all of this, you're telling the court that you want to go forward today?
If the court, if based off of what you just mentioned right now, Your Honor, if you will be just if it's going to be on black and white, and there's really no difference if I have an attorney or not. I do have a very big question on that one word, as Ms. Lopez Foto mentioned. But if there's no real big difference, if I have legal representation on that or not, if it's going to go solely based on the divorce decree, then I feel that we could move forward.
To fully answer your question, I'm not saying that it's going to make a big difference or it isn't. What I'm saying is, as a matter of law, you're going to be treated the same way with a lawyer, without a lawyer, and the question posed to the court is going to be answered the same way whether you have a lawyer or not. Now, the only difference is whether you're going to have legal advice or not. If you're comfortable going forward, it's your decision. It's your request to look for a lawyer and hire a lawyer, but you don't have to. I would surmise, without knowing anything else, that you're going to get the same decision in any event because the decree is going to say one thing and the result is going to produce whatever is in conformity with that decree. Unless you all come up with some interesting scenario that I just haven't seen, but it's up to you. It's your request for more time.
Your Honor, I'm sorry, if it's black and white and the standing will rely on what's stated on the divorce decree, then I'm fine with moving forward.
His request to withdraw the request to continue. Are you ready to go forward, Mrs. Cotto?
Yes, Judge, and this is really just argument. I'd ask the court to take judicial notice of the pleadings before the court. Ms. Galeano filed an original petition to enter the post-divorce qualified domestic relations order on March 17th of 2026. Mr. Tradd was in fact served and he is here making a general appearance. The court filed, actually signed a agreed final divorce decree that has been uploaded to Caseline. And the court signed the same on February the 16th of 2022. I'll ask your staff, Judge, to refer to the Exhibit A, which is the agreed final divorce decree.
You're asking court staff to prompt?
Yes, Judge.
Court staff will do so.
It was A1 through A65.
When ready, court staff will prompt. Mrs. Cotto.
Judge, and I would ask them to prompt page 38 and 39. Keep going. It's R6 on the final divorce decree. It's numbered page 38.
Ms. Flores, I think Ms. Escoto is referring to the final decree divorce pagination. So look
Correct.
for the decree number 38.
There you go. She passed.
Was it 837 and 838?
Page 38, R6. There we go. Here we go, right there. So just these were were on the page where the items that were awarded to Miss Trad then, now Miss Galliano. And on R6, if we can go down a bit further, the court will read a portion of the sums, whether matured or unmatured, accrued or unaccrued, vested or otherwise, together with all increases thereof, the proceeds therefrom, any of the following retirement plans, and then it says as follows. Then on the next page, and the operating word there is increases, Judge. 25,000 of husband's retirement plan in the thrift savings plan through his employment. If the court then now refers to the A66 through 873, which is the actual proposed order signed by Ms. Galliano and I. Okay. On page, starting on the bottom of page 2. There you go. This order assigns to the pay an amount equal to 25,000 of the participants vested. And if we can change the page to the next one. Account balance under the plan as of the liquidation date. The account balance under the plan will include earnings. And obviously there's additional standard language about loans and forms of payments and commencements and death procedures. And Ms. Galliano's position is that because the final divorce decree contemplated any increases of the 25,000, that's should be awarded to her in the retirement order, and that's how it was prepared. I cannot give Mr. Trad legal advice. I explained to him in my email to him why it had the increase language in there, which is the earnings, and he refused to sign. But again, the final divorce decree contemplated and any increases of which are the earnings. But again, I can't give him legal advice. That's why I suggested that he hire an attorney, because I'm not here to explain the language to him. And so Ms. Galliano's request, Judge, that the court sign the proposed order as is, and if the court wishes to not give her those increases or earnings as the decree states, then that's to the discretion of this court.
So let me see if I understand this correctly, Mrs. Scott. Let me ask this question, and then I'll get a response from you, Mr. Trad. If the court understands the considerations in this matter, so the court signed a final decree of divorce in 2022. That's 4 years ago, ostensibly, without knowing anything else. If this was a good investment vehicle for retirement. In 4 years, there have been some increases to that account. Here, what this contemplates is in those 4 years, whatever amount is attributable to the amount that was due to Ms. Galeano should now be given to her. Is that the issue, Mrs. Cotto?
Yes, Judge. So whatever interest, the $25,000, we're not touching anything else from his TSP. It's just the $25,000 and the increases thereof from the 25,000, nothing else.
So here's the question to you, Mr. Trad. So you don't have a dispute that under the terms of the final decree of divorce, Ms. Galeano should get 25,000, correct?
100% agree.
Into the microphone?
100% agree.
So the question before the court is, if this is a good investment vehicle, and I don't know anything about your retirement account, but the way these things work, they're supposed to increase in value through interest and good investments over time. If you have one of these really good accounts, there have been increases from the date of the final decree of divorce till right now. In 4 years, there's been some interest where it's $1 or 100,000, whatever that amount is. The question before the court, as posed by Mrs. Cotto, is, should Ms. Gallardo get the benefit of the interest attributable to her $25,000, yes or no? What do you think the answer should be?
So I do not believe she is entitled to that amount. First of all, as you mentioned, your honor, as the court mentioned, this divorce happened 4 years ago. I do not know why this quadrant wasn't entered at any time prior to that, but to utilize my TSP as a de facto investment account, I don't think that's the correct engine. Now, whenever we went through mediation, which was a 3-hour-long mediation, one of the things that was agreed upon was the finite number, which is on page 39, where it specifically sets 25,000 of husband's retirement plan in the thrift savings plan through his employment. I know Ms. Escoto Lopez mentioned Title R6, but from what I'm understanding, that's more that stanza, that paragraph describes more of the retirement assets. However, what is concrete in this divorce decree was the 25,000. It did, if there was to be, and that's what was agreed upon during the mediation. Now, under subsection A or A under 36, I'm sorry, R6, which is page 39, 25,000 of the husband's retirement plan in the thrift savings plan through his employment had the contemplation been that she would have she was entitled to earnings, then I believe that should have been entered in that section. But when the party's property was distributed equally, that 25,000 was taken into account as being the part of the deciding factor of distributing the property equally.
So in order for the court to make a good decision, Mr. Trad, let me ask you 3 questions. First question is, I understand your argument why Ms. Galeano shouldn't get the benefit of the increase, if any, and I don't know what it could be or is, but let me ask the question in reverse. Why are you entitled to that amount?
Your Honor, I believe that amount, I don't know why she didn't remove it. My understanding, the only reason that I could have found that she did not remove it was because she, for whatever reason, was not going to roll it over into another investment account to where there would not be penalties.
Right. I can't fix what did or didn't happen, but my question is, I understand completely your argument why she shouldn't, but the question that I have is the reverse. Why are you entitled to that?
So I don't see how her failing to remove the monies at an accurate time now puts the onus on me having to be responsible for those actions.
So then let me talk to you, let me ask you a question on remedies, and what remedy means in legal terms is, what should the court do to put you in the same position that you were back then, because that's what you're asking, only 25, because that was what it was ordered back then, and Ms. Galeano, the position she was back then. This is it's a legal term called remedies, but it means, what should the court do? If the court puts you back, as you're requesting, into the position you were back in 2022, if I use your logic and your remedy, put us back in 2022, she gets 25 and we're cut. Well, that means by logical extension, she should get all of the increases, not just her portion, because that puts you, everybody back into the position they were back then. I don't think that would produce a good result.
Understood, Your Honor.
You see the flaw with the argument.
So, Your Honor, that's my stanza. Whatever the court finds that is the most logical, fair,
Yeah.
and within the grounds of the law, then that's what I'll fully respect.
I fully believe that the result that would get to the most fair, right, just orders that effectuate the orders. I mean, these were agreed to, right? It's not like the court said, you get 25 and only 25. This was an agreement. But I think that you should be given all of the benefit of everything but the 25 and interest. And Ms. Galeano should get the benefit of her 25 plus interest, because one more time, I don't see any clear position that the law could give you that says, based on something that I don't know, whether it was this lawyer, that lawyer, or something having to do with your plan, it didn't happen. I can't fix that, right? So the question is, are you entitled to the full thing? I think the law, well, no, I don't think, I know the law would say, no, that's not fair, right, and just, because your bank account, your retirement account has had the benefit of the interest attributable to money that really isn't yours under the law. And if the court agrees with you, the problem is that if I put you back into the position you were in 2022, she gets 25,000 plus the interest on everything over the last 4 years. And I don't think that's a good outcome either. I don't think that's a good, right, and just outcome. So, Ms. Escoto, these are the court's findings. Do you have a proposed order with those parameters?
Yes, Judge, it was what was e-filed with the court and what was on case line.
All right.
The only thing I ask if the court is going to sign the same, TSP requires that an addendum be submitted to not disclose parties' social security numbers or dates of births on these orders for identity theft reasons. And so if Mr. Trad can just send me his social security number so that I can plug it into the addendum, that addendum is not filed with the court. It is sent certified mail to TSP with a copy of the order and a copy of the final divorce decree. If he can just email it to me like he has been communicating with me, I would appreciate that.
Any objection to doing that?
None whatsoever.
All right. Let's do this. I have signed it because I have already ruled. I'm going to tender the original to our coordinator to process with the clerk. If you have an objection, Mr. Trad, I will gladly entertain it on May the 5th. I'm not setting it for hearing, but I'll certainly hear it if there is any. But I fully believe I'm squarely confident that this was the most best, right, and just outcome in this case. Do you have any questions for the court, Mr. Trad?
Thank you for your time.
Any questions for the court, Ms. Galeano?
No, Your Honor.
Any other issues on this case, Ms. Escoto?
No, Judge.
All right, I wish you all the best. We'll see you on May the 5th. Good luck to all.
Thank you.
Thank you, Judge. I have one last case, Judge. That's on page 6 on the Solis Quesada case.
Cristian Quesada versus Robert Solis, cause number 2026 FLA 506C3. Court marks Mrs. Escoto. Are you making an appearance for respondent?
Yes, Judge, I just got hired. I wasn't in the office when Mr. Solis came. And so I conferred with Mr. Arce yesterday and today that my request per the policy of this court was to ask for a short continuance. I will send him an offer of settlement for purposes of temporary orders. I just needed to have some time since I wasn't here yesterday.
Court marks Mrs. Cotto present and participating by video conference. Mr. Arce present and participating by video conference. Good afternoon, counsel.
Good afternoon, Judge. Ruben Arce for Christian Quesada, Judge, and my client is present also, Your Honor.
I'm going to ask
I
that you
did
mute your
confer.
device and tell the court, are you Christian Quesada?
Yes, I am, Your Honor.
Welcome to court, Ms. Quesada. The court marks you present and participating by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Mr. Arce, go ahead.
Your Honor, I did speak to counsel, Judge. That was my understanding that Mrs. Cotto was coming on board just recently, and the respondent just recently got served, Judge. So, and we understand the policy of the court, Your Honor. So because of that fact, we are not opposing a pass on this matter. And I know that I'll speak to Ms. Escoto, Judge, and see what she sends me as far as any documentation, and then we'll respond to the same, Judge.
All right, without objection, I think you all both said the exact right policy of the court. First appearance, necessity to communicate and exchange offers. Ms. Flores, give us another TRO setting, please.
April 22nd at 9 a.m.
All right, Ms. Quesada, keep in contact with your lawyer between now and April 27th. That's the day you'll come back to court. Do you have any questions for the court, Ms. Quesada?
No, Your Honor.
Mr. Arce?
No, Judge.
Did
Mrs.
she say
Cotto?
the 22nd or 27th, Judge? I'm sorry.
I heard 22nd. What did you say?
April 22nd, Your Honor, yes.
22nd. Okay, perfect. Thank you, Judge. And that's all I have. May I be excused?
Good to see you. have a great day.
See you, Judge. Thank you.
Okay, Judge, I have one more matter that's uncontested, Your Honor. It was just an announcement, Your Honor.
Further down the line, Your Honor.
Go ahead, Ms. Flores.
Next case is it's page 2, number 5, Attorney Claudia Laneta Garcia.
That is Julio Cesar Villasana, Joanna Elizabeth Rangel, cause number 2024 FLC 1931C3. Court marks Ms. Garcia present by video conference. Good afternoon, counsel.
Good afternoon, Judge.
Speak into the microphone and to the court. Are you Julio Cesar Villasana?
Yes, Your Honor.
Welcome to court, sir. The court marks you present in person. Are you Joanna Elizabeth Rangel?
Yes, Your Honor.
Welcome to court, Ms. Rangel. The court marks you present and participating by video conference. Ms. Rangel, do you have a lawyer?
No.
Are you going forward without a lawyer?
Yes, Your Honor.
Court marks you self-represented. Good afternoon, Mr. Montemayor.
Good afternoon, Your Honor.
Court marks you present by video conference. We have a final hearing, 6th time set, and a motion to withdraw. Give the court some announcements, please.
Judge, I was appointed a few weeks ago, and with my motion to withdraw, I submitted also copies of the email correspondence to Mr. Montemayor and to Ms. Rangel, trying to get information and set up appointments with the participants. But I didn't get any response. So I'm asking to withdraw, Judge, at this time, because I don't think the parties are interested in my assistance.
Mr. Montemayor.
Judge, for whatever reason, I do not recall getting Ms. Lanes's email, and I apologize. Normally I do confer with Ms. Lanes on other cases as well, and there's never really been any issues. I was not even aware, to be honest with you, that Ms. Lanes hadn't been appointed. We had submitted the order back in January. I want to say it got signed in February, about the 16th or so. But I have no objections to her withdrawing. We're going to tell the court, but I don't recall seeing her email come through on that issue. Now we would have immediately sent our client over there to get the process going. The court is correct. This is a 2024 case, Your Honor. Ms. Rangel's attorney has withdrawn in the interim. We had a temporary order hearing, I want to say back in January, that lasted about 2-3 hours. And the court gave us some temporary orders. There's been visitation that's been ongoing. And that's where we're at right now.
Your Honor, I would ask to withdraw at this time.
Ms. Rangel, do you have any objection to Ms. Garcia withdrawing?
No objections, Your Honor.
I guess several questions before the court considers Mr. Montemayor, if the court grants the request, and it's a non-objective to request in and of itself, but on its own merits, but what proceeds thereafter?
Well, Your Honor, this is it's become more or less of a he said, she said kind of case. I think the child is probably, I think 4, maybe going on 5. And I think we should probably get an ad litem. And I don't want to prolong the case very much
You
longer.
have one here, and everybody's agreeing
I
to let it
agree. You know,
go.
I'm going back to my notes, and I'm going back to my emails and trying to find out where I missed Miss Lanes's email. She says
But I guess that's the court's question. If I grant the withdrawal, the request is going to be for another ad litem for a 7th setting. At that 7th setting, I can almost, I would highly anticipate that some person saying, whoever it is, anybody would say, I just got appointed, I need more time. So we're looking at an 8th setting. Tell the court, rather than answer any of those questions, tell the court what the court can do to help Mr. Villasana and Mr. Angel get to a final hearing.
Your Honor, the only thing I can tell the court is I mean, we can have a final hearing now, but the court's comments at the last hearing was that the court would feel more comfortable with an ad litem. The evidence was rather, I guess not weak, but there was evidence on there was a lot of things lacking, and I think from the court's commentary last time, and so I think an ad litem would probably be the best thing. And I understand Ms. Lanes was appointed for whatever reason. You know, this is an unusual situation for me. I don't have any objections to her withdrawing, but you know, I do think that somebody else's recommendation would help the court make a ruling at this final hearing.
One final thing before I grant the request, should the court do that, Ms. Garcia, anything pending by way of fees?
No, Judge, the only thing that went out were emails, either from me or from my assistant, that just were not responded to. I mean, I'm working from my computer, obviously this afternoon. But no, I have not talked to anybody. I have not read anything. I know nothing about this case. But you know, a lot of times it's hard to collect with, I try to do the best job possible, but if the parties are not interested in moving forward, I'm concerned that my fees won't get paid, Judge. So I would prefer to withdraw.
All right, the withdraw request is well taken. The court has signed it. The court is tendering the original to the clerk's office. Thank you, Ms. Garcia. Are there any other cases for Ms. Garcia?
No, Your Honor, that is all, Ms. Garcia.
Good to see you. Have a great day.
Thank you, Judge. You too.
All right, so Ms. Flores, does the court have Ms. Rangel's email address?
Yes, Your Honor.
Mr. Montemayor, do you have Ms. Rangel's cell number?
I don't have her cell number, but I do have her email address.
All right, Mr. Montemayor, email Ms. Rangel a good number to communicate with you, Ms. Rangel. This is now the 4th contested matter on today's docket. So there's a request to withdraw. There was no objection. The court has granted that. There is no other request to appoint another ad litem. So you're going forward without an ad litem. There's no request to continue. So you're having a final hearing today. Ms. Rangel, you're going to get an email from Mr. Montemayor momentarily. Communicate with him. He's going to tell you what his client, Mr. Villasana, is asking for. There's a chance, maybe, that you can agree to some things, maybe all things, but possibly some things that he's requesting on behalf of Mr. Villasana. And you need to come back to court momentarily and tell the court what things you agree to. And then I need you and Mr. Montemayor tell the court what things you do not agree to. Anything that you do not agree to, the court will hear under evidence, under oath, by your testimony shortly. Do you have any questions on any of this, Ms. Rangel?
No, Your Honor.
Your Honor, if I can get her,
Mr. Villasana? No. Mr. Montemayor?
Your Honor, I'm just going to ask if I can get Ms. Rangel's phone number. I'll call her instead. Be
What is
quick.
a phone number that Mr. Montemayor can talk to you?
Yes, it's 956-355-2773.
All right, so just be on the lookout for his call. He's going to talk to you. As you talk to Mr. Montemayor, you need to know and understand that Mr. Montemayor is not your lawyer. He cannot and he will not provide you any legal advice, but he can tell you what Mr. Villasan is asking for, and together you can reach some agreements, and anything that you don't agree to, I will resolve for you after hearing your testimony. Do you understand all of this, Mr. Angel?
Yes, Your Honor.
All right, stand by, please.
Thank you.
Next case, Attorney Donato Ramos.
This is an add-on from our probate docket. This is the estate of Manuel Escamilla Jr., cause number 2026, PB 97L2. Good afternoon, Mr. Ramos.
Good afternoon, Judge. And first of all, I want to thank you and your staff for accommodating me. I'm having surgery on the 21st, which is the same day as this case was set for hearing. Additionally, thank you for letting me appear in your court without a coat and tie. I've never done it. First time in my life, 57 years. And thank you very much. I have a proof of death that we filed with the court. I also have Mr. Escamilla here with me that can be sworn in to prove up. It's a probate as a minimum of title of his dad's will, Your Honor.
Understood. Mr. Escamilla, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand. Mr. Ramos, go ahead.
Thank you. Would you state your full name, please?
Manuel Eduardo Escamilla.
And Mr. Escamilla, are you the applicant in this case?
Yes, I am.
And Manuel G. Escamilla Jr. was your dad, correct?
Yes, he's my father.
And he passed away when?
January 4th, 26.
Okay. And Your Honor, we have a certified copy of a death certificate as Exhibit A, which we would ask that the court consider accepting into evidence.
Court takes judicial notice. Yes, sir.
Thank you. And where did your dad live?
He lived with me, 212 Wedgewood, Laredo, Texas.
And how long was he domiciled in Texas, in Laredo?
Almost his entire life, minus a couple years for time in California.
Okay. And did your dad own real property here in the state of Texas?
He did.
And he owned personal property, had bank accounts?
Yes.
Accounts with financial institutions?
Yes, sir.
Personal effects and household goods?
Yes, sir.
Okay. Did your dad ever apply for or receive Medicaid benefits?
Medicaid, no.
On or after March 1st, 2005?
No.
He never did, period.
Period.
Okay. Now, attached to your application is the last will and testament of your dad dated March the 5th, 2025. To your knowledge, Mr. Escamilla, did your dad ever revoke the will, or did you ever find another will or anything?
No.
Okay. Your Honor, the will is attached to the application as Exhibit B. And now again, I would ask the court to consider accepting that into evidence.
Without objection, the court does and takes judicial notice.
Okay, thank you, Judge. You're named as the independent executor of your dad's will, correct?
Yes, sir.
Okay. As such, did you become familiar with your dad's estate and what he owned?
Yes.
And what he owed? Did he owe any money to anybody?
No.
And so as of the date of his death, and at the present time, there are no debts owing by the estate to anyone?
No, that's correct.
Okay. And were any children born to or adopted by your dad after the date of the will?
No.
Okay. And did your dad ever get a divorce or dissolution of any marriage after the date of the will?
No.
Does your dad's will leave any property of any type either to the state of Texas, a governmental agency of the state, or a charitable organization?
No, it does not.
Okay. And you feel there is no need to have a formal administration because all of the debts of your dad's estate
Are settled.
are settled and paid and so forth?
That is correct.
Okay. So, Your Honor, we would add that and you're asking the court to accept the will and probate it as what we call as a muniment of title.
Yes.
Okay. We would ask, Your Honor, that you consider admitting this will to probate as muniment of title. We have submitted to you a proof of death, in fact, signed by Mr. Escamilla. We have also submitted to you a proposed order regarding same for the probate.
Mr. Escamilla, in the case of your father, cause number 2026 PB 97L2, the court at this time finds that it has jurisdiction over this court, meaning this is the proper court form and venue to consider admitting his will into probate as muniment of title. The court hereby takes judicial notice of the entire case file and has now also had and heard the benefit of your testimony. The court finds that your father passed away on the 4th day of January 2026, having left a valid and enforceable unrevoked will dated March 5th, 2025. The court finds that you have sufficiently pled and proven all of the elements and requirements necessary for the court to grant your request. The court hereby grants your request and admits your father's will into probate as muniment of title. I've also now had the benefit of receiving and reviewing the proposed order by your lawyer. It is in due form. The court is signing that.
Thank you.
Thank you, Your Honor.
I just want to ask the clerk's office, the proof of death and all of those things, are they in due form and acceptable?
Yes, that's correct, Your Honor. I do have a question. Will there be an oath of no debt?
I'm sorry, what was that?
An oath of no debt by the estate?
If we need to submit one, we will. He's already testified to no debts, and the proof of death affidavit that you have also establishes that. But I'll do whatever else you need.
So let me tell the clerk, I think for the court's purposes, I think because Mr. Escamilla is under oath, that suffices for the court's requirements. However, is there any additional requirements that it be in writing and filed with the clerk's office?
No, Your Honor.
All right. I've signed the order. It should be available as soon as early as tomorrow. Mr. Escamilla, the court has granted your request in full. Do you have any questions for the court?
No, sir. Thank you very much for your time.
Anything else on this case, Mr. Ramos?
No, again, thank you very much. Tuesday, I have a carotid artery surgery, so say a little prayer for me. Thank you, Judge.
You absolutely will have that, Mr. Ramos. I wish you and your health all the best during this time and process. And Mr. Escamilla, you have the court's condolences. I wish you and your family well.
Thank you very much.
Thank you, Judge. May I be excused?
Yes, have a good day.
You too. Have a good evening. Yeah.
All right, the court will stand at ease momentarily. Good afternoon. Court is back in session and we are once more on the record. This is the family law docket held in person and by video conference for Thursday, April 16, 2026. The time is now 4:53 p.m. Ms. Flores, would you call the next case, please?
Yes, sir. That'll be Attorney Ruben Arce, page 6, number 16.
Magdalena Villarreal, 2026 FLC 261C3. Court marks Mr. Arce present and participating by video conference. Magdalena Villarreal, are you present?
My client's not present, Judge.
Mr. Arce, go ahead.
Your Honor, on this matter, we had filed a motion for temporary orders, Judge, on a previous matter, Judge. The reason that we're set for status, Your Honor, was to see if we would get this matter service through publication. Just to let the court know, Judge, I believe it was already set up on 4/10 was a date, and there's already a return on 4/14. So we're just gonna ask for some time, Judge, for that time to run, to see if anybody files any type of response or answer, Judge.
Are you asking then for a final hearing?
Yes, Your Honor, being that we're just gonna ask for a final hearing, not temporary orders, just to see if anybody answers, Your Honor, and that way we can get it heard all at once.
Well taken, understood. Ms. Flores, give us a final hearing date, please.
Yes, sir. How much time?
Well, there's some service, excuse me, an answer date. So give us 30:45.
June 18 at 9 a.m.
Any objections?
No, Your Honor, that would work. Your Honor, I believe it was 28 days from the 10th, so anything mid-May or June would work.
All right. Any other cases for Mr. Arce?
That is all for Mr. Arce.
It's good to see you, Mr. Arce. Have a great day.
Thank you, Judge. Have a good afternoon.
Thanks.
Next case, Attorney Nathan Chu, page 4, number 11.
Ismarie Lopez versus Naum Lopez, cause number 2026 FLA 68C3. Court marks Mr. Chu present and participating by video conference. Ismarie Lopez, Naum Lopez, are you present?
Yes,
Yes, Your
sir.
Honor.
Are you Naum Lopez?
Yes, Your Honor.
Welcome to court. The court marks you present and participating by video conference. Mr. Lopez, do you have a lawyer?
No, sir.
Are you representing yourself?
Yes, Your Honor.
Are you Ismarie Lopez?
I am, Your Honor.
Welcome to court. You're joining us by video conference. Are you on your bed?
Yes.
Get out of your bed. You're in court.
Okay. Sorry.
All right. Welcome to court, Ms. Lopez. As you can see and hear from your device, your lawyer is also present and participating by video conference. Mr. Chu, go ahead.
Good afternoon, Judge Nathan Chu, present for Ms. Lopez. We filed a motion for continuance. Probably asked the court to abate this case or put it on the inactive. The parties are attempting to reconcile, Your Honor.
All right. Well taken. The court has signed that order. The court finds that the parties are attempting to reconcile. Ms. Flores, give us a setting in 3 months, please. Time in late July.
July the 30th at 2 p.m.
So take this time, Mr. Lopez and Ms. Lopez, to talk to each other and to see if there's any possibility that you get back together. If you do, the court wishes you well. And if you don't, the court is here for you to hear your case. Ms. Lopez, do you have any questions for the court?
No, I don't, Your Honor.
Mr. Lopez, do you have any questions?
No, Your Honor.
I wish both of you and your families very well. Have a good day.
Thank you.
Thank you.
Any other cases for Mr. Chu?
That is all for Mr. Chu.
Good to see you, counsel. Have a great day.
Same here, Judge. Bye-bye.
Thanks. Bye.
Recall, Your Honor, Attorney Marcel Knudsen, page 2, number 3.
That is Alma Alicia Salas Vasquez versus Anthony Bouvier, cause number 2018 FLI 1884C3. Court marks Ms. Alania present and participating by video conference. Mr. Knotson present in person. Are you Anthony Bouvier?
Yes, Your Honor.
Ms. Alma Alicia, there you are. Are you Alma Alicia Salas Vasquez?
¿Es usted Alma Alicia Vázquez? Yes.
Court to present by video conference once more.
El juzgado de la marca presente por medio de conferencia una vez más.
Mr. Knotson, Ms. Aldana, a little bit slower than normal to allow for translation. Go ahead.
Yes, Your Honor. I took Your Honor's words to heart, and I worked diligently with Ms. Saldana and both of our clients. And we have an agreement we'd like to announce to the court.
Tomé las palabras que usted me dijo a pecho y conjunto con la señora Saldaña hemos llegado a un acuerdo que quiero anunciar al juzgado.
Yes, sir.
Okay, temporarily, basically for visitation, she will have tomorrow, the mother, from 3 p.m. after school. She will pick up the child from school, which is Tarver Elementary, have them from 3 to 8 p.m.
Translation.
Para en órdenes temporales en visitas va a ser el día de mañana a las 3 de la tarde después de la escuela. Él va a Tarver Elementary de las 3 a las 8 de la noche.
And all the drop-offs will be on McDonald's at the corner of San Bernardo and close by Colton.
Y todos donde lo va a dejar y lo va a recoger va a ser en el McDonald's que está cerca de San Bernardo y Calton.
And then she'll have us April 17th tomorrow, and Saturday, April 18th will be from 9 a.m. to 6 p.m.
Y eso va a ser el día 17 y el 18 de abril va a ser de las 9 de la mañana a las 6 de la tarde.
Drop off and pick up at McDonald's.
Lo va a recoger y a dejar en McDonald's.
On this Sunday, April 19th, the same time from Sunday at 9 a.m. to 6 p.m., pick up and drop off at McDonald's.
Y el domingo 19 va a ser igual, de las 9 a las 6 de las 9 de la mañana a 6 de la tarde y lo va a recoger en McDonald's.
Okay. And on, she's going to take off this weekend. Normally she works on the weekends, but on April 30th, on Thursday, it will be 3 o'clock after school till 8 p.m.
Y normalmente ella trabaja los fines de semana, pero va a descansar y el día 30, el día jueves 30 va a ser de 3 de la tarde a 8 de la noche.
And pickup will be at school at 3 p.m. and drop off at 8 p.m. at the McDonald's.
Y lo va a recoger a las 3 de la tarde en la escuela y lo va a dejar a las 8 en McDonald's.
And then on Friday, May 1st, will be 3 p.m. pick up at school and 8 p.m. drop off at McDonald's.
Y el mayo primero va a ser, lo va a recoger en la escuela a las 3 de la tarde y lo va a dejar en McDonald's a las 8 de la noche.
And on Saturday, she will have the child from May 2nd, pick up at 6 p.m., drop off at 9 p.m. at the McDonald's.
Y el día sábado 2 lo va a recoger a las 6 de la tarde y lo va a dejar a las 9 de la noche en el McDonald's.
And for that second weekend that she'll have, if the child feels comfortable, it was, to get to be with the child again and make sure things smooth over. If he wants to spend the night without any force or duress on each side, neither parent to interfere with the child, just let that happen naturally. We've agreed that if the child wants to spend the night, that second weekend, they can do so if he feels comfortable.
Translation.
Y el segundo fin de semana hemos acordado a las dos partes que si el menor se siente cómodo, puede pasar la noche con ella si es que las dos partes están de acuerdo y si el niño se siente cómodo.
And we've also agreed that the mom can be added at the school. My client just gave him a copy of the order. He didn't request that she be taken off. Maybe their lawyers advised him, but she can be added to get school information. We have no objection to that.
Y no tenemos ninguna objeción en que la madre sea agregada para recibir información en la escuela. Y mi cliente simplemente entregó la orden. No sabemos si a lo mejor los abogados de la escuela hicieron los cambios, pero nosotros estamos de acuerdo en agregarlo.
And we also agreed we'll put a provision in there that none of his teachers or any other school officials, principals, nurses, etc., or to talk to the child about the case or ask questions about the mom regarding what he does with the mom or the dad, and then we will just send that to the school attorney at LISD to handle reporting.
Y vamos a poner una anotación donde ninguno de los maestros, las enfermeras o los directores deben de hablar con el menor de qué es lo que pasa con el papá o con la madre y vamos a mandar esa notificación a él a él.
And I know the court gave us a date of May 5th. We'd like to have a date either on that date or for the court to interview the child in chambers, unless the court had time to do so today, to do a half-day mediation with Judge Letty Martinez. I think we can reach a final agreement. We're both in agreement to that, subject to approval by your honor.
Y creo que el juzgado nos dio la fecha de mayo 5 para entrevistar al menor, al menos que el juzgado pueda tener tiempo el día de hoy. Y hemos estado de acuerdo en tener medio día de mediación con la juez Letty, si es que el juzgado lo aprueba.
And the last thing I think I forgot was Ms. Saldana asked that both parties will have a right to talk to the child like after school for about 5 to 10 minutes to see how his school was, how he's doing, for the parent not in possession. So I think the mom has the child's telephone, so she can give that to the child and so they can have that communication. And I think that's the agreement.
Creo que de acuerdo con la señora Saldaña, el menor va a tener el derecho de hablar con el padre que no está en posesión de él después de la escuela de 5 o 10 minutos. Creo que hay un teléfono que él que tiene acceso y creo que ese es el acuerdo que tenemos hasta ahorita.
Ms. Saldaña.
Señora Saldaña.
Yes, Your Honor, I would just add that about that neither party be allowed to talk to the child about the case.
Yo simplemente agregaría que ninguna de las dos partes hable con el menor sobre el caso.
That's free.
Y estamos de acuerdo.
Sorry. And from what I understood, May 5th was going to be the motion for the judge to confer with the child, a motion that Mr. Marcel Natson would be filing. It was what we understood.
Yes, that's fine. That's
Creo
correct.
que el día 5 es la fecha que propusieron para que el niño sea entrevistado y creo que el señor Notson va a hacer la orden.
And then we were just asking for, yes, the motion for the judge to confer to be filed by Mr. Notson to be heard May 5th.
Y creemos la solicitud va a ser hecha para que le sea escuchada por el juzgado por medio del señor Notson en el día mayo 5.
Well, let me ask you this, because what I heard from Mr. Notson, and if I misunderstood, I apologize,
Lo que yo entendí de parte del señor Notson fue esto, discúlpenme si entendí mal,
was that there already was an agreement that the court would interview, that there is no agreement on that point, Ms. Saldaña?
Right.
que había un acuerdo. ¿Acaso no hay un acuerdo, señora Saldaña?
Right. My client has concerns because the child is autistic. The child is under 12 years old, but also autistic.
Mi
So that-
clienta tiene una preocupación porque el niño es menor de 12 años y es autista.
So there is no agreement on that issue.
Entonces no hay un acuerdo en ese tema.
So I would just ask that Your Honor set that for hearing at your earliest convenience and
Yeah.
Yo solamente le pediría a su señoría que lo ponga por una audiencia lo más pronto posible.
the child's over 11 years and 6 months old. He'll turn 12 and he is autistic, but he seems like a bright boy. It's not like he's shy or like the Rain Man or something of that nature, but it's something very quickly the court will be able to determine.
El niño tiene 11 años y 6 meses, ya casi cumple los 12. Sí es autista, pero no es tímido y no es como el Rain Man. Creo que es algo que el juzgado va a poder determinar rápidamente.
And I'm not sure what date we have for the to do an informal mediation. We are both in agreement with that.
No
I'm not-
tenemos aún una fecha para una mediación informal.
Maybe we could have that when Judge Martinez is available. We can have that done maybe around the 5th. And then we can set, if necessary, for the court to interview the child if the court grants it. It doesn't hurt for the court to do that.
Y creo que la mediación con la señora Martínez, que creo que sería alrededor de, si podría ser antes del día 5, para que el juzgado tenga tiempo de entrevistarlo. No creo que cause ningún daño.
Yes, Your Honor, we were hoping to get a mediation with Judge Letty Martinez, if she's available this week, next week, as soon as she's available.
Sí, su señoría, quisiéramos una mediación con la juez Martínez, ya sea esta semana o la semana que viene, lo más pronto que ella pueda.
I'm sorry, I meant next week or the week after.
Ya la semana que viene o la siguiente semana.
First week of
Miss,
May.
O la primera semana de mayo, si se pudiera.
Miss Flores, do you know how many? I guess no. How many is not the right answer. Not the right question. Do you know if Miss Saldana or Mr. Knudsen have any cases with us on May the 5th other than this one?
Let me look into your.
Thanks. Look at your calendars, Miss Saldana and Mr. Knudsen, and
Yes,
you let the court know. Do you have cases here on May the 5th
Revise
other
su
than this
calendario,
one?
sí. Señor Ronson, a ver si tienen un caso aquí en mayo 5.
I believe Mr. Knudsen does.
I have a 2 o'clock.
Okay.
Yo tengo a las 2 p.m. y creo que el señor Ronson también.
That's the next date that Associate Judge Martinez has for mediations. I was just going to tell you, go there and then come here, but you can't because you have to be in court.
Oh,
Esa es la
both of
siguiente
you.
fecha que tiene disponible la juez Martínez, pero
Actually,
van a
on
estar
it-
aquí.
My apologies. Actually, it would be this case because you were gonna set up the. You, correct.
Right. So other than this case, do either council have cases here?
I don't see him, I don't see either council, set up or made,
Fifth.
May the 5th.
That'd be perfect.
Ms.
I-
Alani?
I represent Yvette Vasquez in a final pretrial 2 p.m. May 5th.
Yo represento a Ivette Vázquez en un juicio final en mayo 5.
Well, then that
Maybe that can be heard at 1:30 and do the mediation at 2, or what were you thinking, Judge?
I need to look for an available date for Judge Martinez.
Because maybe I could, be in and out. Like I could come into court and then go back to mediation.
Pueden entrar y salir, ir a la mediación y regresar al juzgado.
Is that the only case you have?
Es el
No.
único caso que se tiene.
I'm sorry, I have a CPS status.
Tengo un caso de CPS, un estatus.
On that same date and time?
Yes, Your Honor.
A la misma hora, la misma fecha, sí, su señoría.
And what time was Judge Martinez available?
No, I'm not gonna set
Yeah.
Ms. Alania up to bounce around between courts. That would not be good for anyone. Let me just give you Judge Martinez's next date, which is May the 11th
La fecha de mayo 11, que es la siguiente fecha que tiene disponible la juez Martínez,
at 1:30.
a la 1:30.
Your Honor, I have two trials at 1:30 on May 11th.
Su señoría, yo tengo un juicio.
You can't get
I
that
tried
pretrial?
really hard because her after that, her next available one is June the 9th.
Traté porque la siguiente que tiene disponible es en junio 9.
Any objection to that date, Ms. Alania?
¿Alguna
No.
objeción a esta fecha? No.
Mr. Knudsen,
Señor Norton,
June 9th,
at 1:30.
a la 1:30.
yes, I'm fine, Judge.
Está bien, su señoría.
And Judge, I would just like to see if we can still keep that May 5th, to interview the child unless you want to hear it before then, and if it's granted, then talk to the child on May 5th.
Quisiera ver si podríamos quedarnos con
We
la
can
fecha
bring them
de,
after school.
de mayo 5 para entrevistar al menor. Podríamos traerlo después de la escuela.
Your Honor, if I may, did Ms. Aldana mention the May 11th setting, in this courtroom?
No, I don't know.
I think
I
she
have
said
the 41st, but I mean,
She has a trial somewhere else.
Okay.
a pretrial,
41st.
May 11th.
May 11th, I have the 341st trials.
All right, so let's do this. So you're scheduled with Associate Judge Martinez on June the 9th. Ms. Flores, give us a,
Ya están puestos para ver a la juez Martínez en junio 9.
At 1:30.
at 1:30. I'm gonna schedule this for final pretrial hearing on June the 16th at 2 p.m.
Voy a poner una audiencia previa a la final en junio 16 a las 2 p.m.
and a final hearing that Thursday, June the 18th at 9 a.m.
Y audiencia final en junio 18 a las 9 de la mañana. El jueves.
What the court is doing with this is you can come in on the 16th if there's no agreement and argue the interview if there is no agreement.
Si no hay un acuerdo, el día 16 pueden venir y hablar sobre la entrevista si es que no se ha llegado a un acuerdo.
And unless the child is in summer school, you don't have to worry about pulling that person out of school to come into court.
Y una vez que estén en el verano, ya no tiene que mortificarse por sacar al menor de la escuela.
If granted, the court would likely hold that interview either on the 17th or 18th.
Y es que se les concede y la entrevista sería lo más probable el 17 o el 18.
But don't bring him in or her in. Don't bring the child into court on the 16th.
Y no traigan al menor al juzgado, por favor, el día 16.
Anything else I missed, Ms. Saldaña?
¿Algo más que me haya faltado, señora Saldaña?
No, Your Honor.
No, señor.
All right, Ms. Salas Vasquez, do you have any questions for the court?
Señora Salas Vázquez, ¿tiene alguna pregunta para el juzgado?
No.
Mr.
No,
Bouvier,
sir.
do you have any questions for the court?
Oh, Your Honor.
Señor Uribe, ¿tiene alguna pregunta para el juzgado? No, pues señor.
Anything else, Ms. Saldaña?
No.
¿Algo más de Saldaña? No.
Mr. Knudsen?
No, Judge, thank you so much for your time and patience.
Gracias es todo, señora, y gracias por su tiempo y paciencia.
Ms. Salas Vasquez, Mr. Bouvier, I wish you both very well. Have a good day.
Salas Vázquez y
Thank
señor
you,
Bouvier,
Good
les
to
deseo
see
lo mejor.
everyone.
Que
Good to
tengan un
see
buen
you
día.
too, Judge. May I be excused?
Yes, sir.
Have a good day.
Do.
Next case, page 1, number 1.
This is Rogelio Saucedo Jr. versus Nalia Guerra Ernesto Guerra, cause number 2016 CVG 1382C3. Court marks Mr. Tamez present in person, Ms. Aldana present by video conference. Rogelio Saucedo is present in person. Ms. Nalia Guerra and Ernesto Guerra are present by video conference. Counsel, what is the announcement?
Yes, Judge, as to the two motions pending before the court today, on the motion. to
Well, there are
compel-
three.
Sorry,
There are three.
I have two.
Motion for enforcement, motion to compel, and appointment of an appraiser.
For the
Motion to compel,
enforcement, we're gonna go to mediation. We're gonna go to mediation for that.
Well, I don't know what the motion for enforcement means, but I have two, motion to compel and motion to have the court appoint appraiser.
The motion for enforcement of property division and modification of the child support order was filed by,
Well, that's me, but I think that's on the merits. I don't know why that's.
oh, they're not, well, no, there's a petition and then there's a separate motion.
Really?
You said on both.
Okay, well, I think the motion itself, Judge, is for purpose of the petition on the merits, which that's still pending based on
Sure,
protracted discovery issues that we're having in this case.
sure.
Before we continue, Your Honor, there is background noise from Ms. Guerra.
Ms. Guerra, we're gonna put you on mute momentarily because we want to make sure we have a. There it is. All right. All right, I apologize. Go ahead.
No, Your Honor, my apologies if that, for some reason, that was confusing on my part. I'm not sure what that motion was, but on the motion to compel, Judge, this was a discovery that was propounded on Mr. Guerra, and we never received any responses. Council has agreed that the objections have been overruled, serve discovery responses are within 2 weeks. The motion to appoint the appraiser, Your Honor, that is based on the report that the Master in Chancery, Mr. Sigifredo Perez, filed with the court. And so for purposes of effectuating that report from the Master in Chancery, the parties have agreed that they will name Paul Porras to conduct an appraisal of the property at issue, that being the apartment. And then we can file an advisory with the court with that appraisal. I don't think we discussed this with Ms. Saldana, but I would propose that Mr. Porras's cost be divided equally amongst the three parties, 1/3 each.
Ms. Alania?
I am requesting that if it's gonna be divided, that at the very least it be Mr. Salcedo and Ms. Guerra 50-50.
And the only reason I say that is because, as we heard prior, Mr. Guerra continues to say that he owns the property. So I think it's only fair that the parties split that 1/3 each. We've got a person claiming legal title and two people that have claimed equitable title pursuant to the court's decree. So I say we split it 1/3 each.
Yikes, what a difficult call you all set up for the courts. So on the one hand, because normally what I would say is everybody get, 50-50, you have two sides. Ms. Saldana says special appearance, this person isn't here, he owns it but shouldn't pay. And that seems like an inconsistency. Well, I've overruled the special appearance. If there is an agreement, let me think about this. If there is an agreement that that the thing be appraised is the true, right, and just and equitable thing to do to be divided half or 1/3, Mr. Tamez argues that he is a proper party and has been served. Ms. Alania says it's his property, but isn't really here. If it is his property, why wouldn't he be subject to pay equally with everyone unless he isn't an owner and then he had nothing to do with this? You see the inconsistency. I mean, it's like he wants both things. He wants to be an owner, but not have anything to do with the allocation of this court's ruling at the end of the day. I mean, it would have been a lot easier had the reverse been true, had Mr. Tamez said there's two sides 50-50, and Ms. Alania said, no, he's an owner. We disagree with the court's ruling, but he's an owner, so he gets to chime in. But now she's saying he's an owner, but he's absolved of any payment on this. What an interesting situation. I mean, crystallize your arguments, Mr. Tamez. Why should Mr. Guerra pay? And I'm going to ask you the reverse, Ms. Alania. Crystallize this, please, because I see that there's just some logical inconsistencies with saying, you didn't serve me, I'm not really here, it's my property, I'm not paying to have my property evaluated. Give me why should Mr. Guerra pay Mr. Tamez?
Yeah, so as I mentioned before, Judge, the law recognizes title, right? Title ownership is an incidence of ownership. The court and our legal system in Texas also recognizes equitable title. Now, from what I've heard from counsel in representing Mr. Guerra, she's saying, I don't care if the court adjudicated equitable title in Mr. Saucedo and Ms. Neyla Guerra. The owner is Mr. Guerra. Okay, that's going to be litigated. That's going to be determined to what extent. But because of that, the law recognizes bare legal title and equitable ownership. In this case, I'm assuming we have three parties. We have one plaintiff, two defendants. They're all making claims of ownership, equitable ownership as to Mr. Saucedo, equitable ownership as to Ms. Guerra, and bare legal title for Mr. Guerra. So I think equally all three should be burdened with this cost because that's the argument they're making.
Response, why should Mr. Guerra not take a 1/3 of this bill, Ms. Alania?
This is an enforcement of a divorce decree. A divorce between husband and wife. They're the ones that Mr. Saucedo is seeking some remedy from Ms. Neyla Guerra. As far as any arguments about title, that should have been done in 2017. And therefore, our position remains that Mr. Guerra was not made a party. And therefore, to say we have equitable title just because we said so is inappropriate because the true record owner was never brought in. And now, not only was he denied due process back then, now he's being told, in addition to that, now you have to pay 1/3 of this appraisal. It's unjust.
Let me ask you this. Let me ask you both this, and I don't know the answer, and the answer to these questions is going to resolve this issue, although it's a 1/3. I can't imagine that this is, I don't think anybody should be losing sleep over this, but I do want to get it right in any event. So, what in the record, Mr. Tamez, and I'm going to ask you the same question, right? Maybe I'll start in reverse this time. Ms. Alania, and then I'm going to ask you, Mr. Tamez. Ms. Alania, what in the record reflects that Mr. Guerra is an owner, whether in title or in equity or anything else? Because what the court presumes at this juncture is that the only finding is in the final decree of divorce, May of 2017, that says there's two owners. So just on that, just at that one time one, there's two people, there should be two split 50-50. But I think your client, Mr. Guerra, is now making the argument that he's some sort of owner. If that's true, then he should partake in this fee. So tell the court what in the court's record, in the case file, evidences shows and proves that Mr. Guerra is a title owner, either in fact, in equity, or anything else.
The final divorce decree orders him to sign a special warranty deed because they recognized that he is the title owner. Again and again, we have filed a deed showing that he is the title owner. Again and again, we filed pleadings showing that he is the title owner. And that he was never given due process to defend his title.
Same question, Mr. Tamez?
Yes, Judge. I think what counsel misses is that there's two types of ownership. And bare legal title does not mean that my client or the court could not adjudicate that they have equitable title. I understand this argument. I think that's been discussed ad nauseum. The gentleman is before the court. The gentleman is here, and I assume the gentleman is continue to argue that it's his property. So if the gentleman is going to continue to make that argument, that I think the gentleman needs to be proportionally charged with the expenses of defending this bare legal title that he's claiming. I think that's equitable. If not, then that's fine. We'll split it 50-50, but I think that will cut against this argument because you can't have that duality. You can't make at one time an argument that I am the owner at the same time saying, but I'm not going to take any responsibility and pay no expenses as a true owner. So it's inconsistent and it's, yeah, we can't have it both ways. But you're right, Judge. At the end of the day, I think Mr. Porras charges $750. It's not going to break anybody's bank. We'll live with whatever order the court decides, but this is just another example of how we're having these inconsistent claims being brought before the court. And yeah, I'll stop there.
It's never been inconsistent. I've always advised the court that Mr. Guerra was never given due process. I've never been inconsistent about that.
The inconsistency is in the failure to recognize title, bare legal title, and equitable title. As the law is recognized in the state of Texas and has long been recognized in the state of Texas, that exists. Ignoring it does not make her position correct.
Well, they ignored the due process. They ignored joining Mr. Guerra as a party to defend his title record to people who are claiming equitable title. He was supposed to be joined and he wasn't.
It's the language that I'm mulling over. So under petitioner 7, the portion of the decree that awards the house, both parties affirm, and they acknowledge on page 31, they acknowledge that they've had time to review, they acknowledge receipt of the decree, they acknowledge they were represented. So everybody knew what they were getting into, and nobody can take that back. Not Mr. Saucedo, not Ms. Guerra. But then on petitioner 7, the line item that designates the house, it clearly says that these two parties own a 1/2 interest. Doesn't mention anybody else. Now, that has to be tempered with the portion on page 30 that says, but there's going to be a special warranty deed between the parties. And then on page 29, it does. Now I see Ms. Alania's point. On page 29, it mentions Mr. Ernesto Guerra. So what's clear to the court is that the parties, and in this case particularly, Ms. Guerra, contemplated this and entered into this agreement being fully advised, but haven't been given an opportunity to read, review, and object to if it was an incorrect decision. But there is also nothing in the record that allows the court to crack that egg open. In other words, I can't undo that. I see the inconsistency, but there is nothing in the record that allows this court to go out and change that. So this is the result. The only two parties that were party to that decree are Mr. Saucedo and Ms. Guerra. So the cost is split 1/2 each. But it's clear to me that Mr. Guerra has a claim against Ms. Guerra for that representation, whether it was truthful or not. That's where it stands.
I'm curious, why isn't Mr. Salcedo involved if he made that same allegation? Why is it only Ms. Guerra that's being pointed out?
I would answer that question by the fact that they're sitting right next to each other, Judge. It's father and daughter. I mean,
That is not sufficient.
you know,
If the question, Ms. Saldana, is whether each party had a legal duty to disclose, I think the answer is yes. I think Mr. Salcedo had a legal duty and Ms. Guerra had a legal duty. If the question is who had the moral obligation to advise the parent that they were being brought into the suit in this manner, I think the answer is clear too. But as a matter of law, I think you're right, Ms. Saldana. As a matter of law, you are right.
As a matter of law, it is a void order to order him to sign.
All right, already ruled. Those are the orders of the court. We will see you here. You said that there was an agreement to mediate. Did the court hear that?
I think that's not accurate at all. We had an agreement to mediate back in January, and the agreement that I had with Ms. Saldana was you produce the documents that I'm sending you in discovery because I need that information to make a fully apprised and acknowledged recommendation to my client at mediation. The path that has been chosen by the respondents is to obfuscate discovery, as you can see by today, and as you can see by the fact that I had to file a motion for contempt with a show cause order.
So knowing all of this, knowing that there's now an agreement as to the responses and now the appraisal, and now the court even sided with Ms. Alania as to the disposition, the payment and division of that bill, how much time would be reasonable? And I think, are you going back to the master or not?
I don't think so, Your Honor, unless if we need to take depositions to further discover some items, we can possibly do that. But for now, I think it's getting the appraisal. I have a motion to for contempt.
Knowing the but I thought there was an agreement on that.
On the what?
On the motion for contempt.
No, that's just on the motion to compel. Separately, I just filed last night a motion for contempt with a show cause order on Ms. Neyla Guerra, because aside from the fact that we already had to file a motion to compel discovery responsible for her, I still have not gotten the discovery responses. And so I was forced to file a motion for contempt on Ms. Neyla Guerra. Today was just a motion to compel Mr. Guerra.
Well, so knowing all of these things, Ms. Alania, knowing that there's an agreement as to the responses and no objection, the objections being waived and the 2 weeks, and now Mr. Porras is coming in to do the appraisal, what type of scheduling order, how much time would be reasonable and necessary to schedule, I guess, the contempt, which ostensibly could be moved if this thing is resolved, and then a final hearing, Ms. Alania?
I would ask for 45 to 60 days because I did give Mr. Tamez all the documents that Ms. Guerra was able to give to me. He's asking for more detailed information. So in order to be able to go back through the years to try to get that, then we're gonna need some more time.
Ms. Alania says 45 to 60 days is reasonable and necessary. Response, Mr. Tamez?
For a trial on merits, 60 would be the minimum based on the way this thing is being discovered and litigated.
A minimum. So there is no objection to that. Now, regarding scheduling, if you're asking for a final setting in 60 days, and that was the max that Ms. Alania was asking for, are you asking for a separate setting on the show cause?
Yes.
How much time would be reasonable and necessary for that hearing?
Just to, how much, as far as
2 weeks, 4 weeks, 6 weeks?
Minimum a week, Judge, 2 weeks, so I can get Ms. Neyla Guerra served with precept.
So,
if her responses are due in 2 weeks, does what procedurally or factually would one have to come before the other?
No, so the responses that we've agreed to serve in 2 weeks is the ones on the discovery on Mr. Guerra. Motion for contempt is on Ms. Neyla Guerra. And I have plenty of reasons why in the motion to contempt that it's not just as easy as saying, oh, she gave me everything she has. But a lot of time has been spent on this, Judge, unnecessarily. But this is the path that the respondents have chosen, and so I.
Mr.
made the motion
Tamez
to get-
says 2 weeks on the show cause. Your response, Ms. Alanya?
I agree, the order with the real property is void. So yes, a lot of time has been spent on this.
I've ruled, and I appreciate the argument. I think it was a good argument. I've already ruled. I understand, Ms. Alanya. I understand your position. It just doesn't help to hear the same argument when I've already ruled. And my question is, for Mr. Tamez's request, unless you tell me that 2 weeks is not reasonable, I'm going to set that. Please answer that question.
I was asking for 45 to 60 days for Nyla's contempt so that we can try to get the information that he's asking for, because he's asking for years from before.
That's the
So
answer that I needed
That was what
to
I was
hear.
asking.
All right. We'll come back on the show cause on May 19th at
I'm out of town that day. I have a vacation. This time I do know that I have a vacation letter.
yes, it starts on the 18th. It's been calendared. Come back on May the 5th at 1:30. Any objection, Ms. Alanya?
Yes, Your Honor, that is not sufficient time to get all of the information.
Your Honor, if I could just, so the discovery responses were due back in January. So I don't know how much more time council needs after I've already filed a motion to compel, had to come to court, get an agreed order. And I still don't have the responsive documents. And we're now in April. So conceivably, Ms. Nela Guerra has had 6 months, half a year to compile the documents that have been requested, which are in her possession, custody, or control, and answer each one of those interrogatories fully. I just don't know why it would take that much time, Judge. Under the rules give us 30 days.
Whatever is in her possession, custody, and control is what she handed over to Mr. Thomas's client. So she didn't do anything wrong. She didn't hide anything. She gave what was in her possession, custody, and control. If he wants more, then we're asking for time so we can try to get more. You know, maybe I would like to confer with him and see exactly what he's asking for, because I gave him what she gave me, what
All
she
right,
had.
we'll come back on the show cause order on May the 5th at 1:30. We'll come back for final hearing on June the 18th at 9 a.m. Anything else on this case, Mr. Tamez?
No, Your Honor.
Ms. Alanya?
No, Your Honor.
Do you have any questions for the court, Mr. Salcedo? Court has heard no. Ms. Guerra, do you have any questions for the court? Court has seen no. Mr. Guerra, do you have any questions for the court? I didn't hear that. Can you? Yes.
No.
Thank you, Mr. Guerra. Miss Alanya?
Yes, Your Honor. June 18th at 2 p.m.
Excuse me, June the 18th at 9 a.m.
9. Thank you.
Mr. Saucedo, Ms. Guerra, a lot of moving parts, a lot of first-time issues that haven't been contemplated, certainly not in this specific type of scenario. So keep in contact with your lawyers. They're going to continue providing you some good legal advice and preparing you for your hearings. Mr. Saucedo, Ms. Guerra, and Mr. Guerra, I wish you all very well. Have a good day.
Thank you, Your Honor.
Yeah. Any other cases for Mr. Tamez or Ms. Alanya?
That is all for both attorneys.
It's good to see you both. Have a good day.
You too. Last case, Your Honor, page 2, number 5.
Julio Cesar Villasana versus Joanne Elizabeth Rangel, cause number 2024 FLC 1931C3. Court marks Mr. Montemayor present by video conference, Mr. Villasana present in person, and Ms. Rangel present by video conference. Mr. Montemayor, what is the announcement?
Your Honor, we weren't able to come up with an agreement. Both parties want the same right to establish the primary residency of the child. And one lives in San Antonio, one lives in Webb County.
Who lives in San Antonio?
Miss Rangel.
Mr. Villasana lives in Webb County?
Yes, Your Honor.
Where does, how many children or child before the
Just
child
one,
children?
Your Honor. Juliet, Juliet Villasana.
And she is how old?
She is she just turned
She turned 6.
6 year old. 2020 is her birthday.
Mr. Villasana, Mr. Rangel, raise your right hands. Do each of you solemnly swear or affirm that the testimony you will provide in this case will be the truth, so help you God?
Yes, Your Honor.
Both have answered yes. Mr. Villasana, is your true and correct name Julio Cesar Villasana?
Yes, Your Honor.
You heard the factual background that your lawyer told the court. He said that you live in Webb County, Ms. Rangel lives in San Antonio, you have one child with her, and she is a 6-year-old female. Is that all true and correct?
Yes, Your Honor.
Same questions to you, Ms. Rangel. Is your true and correct name Joanna Elizabeth Rangel?
Yes, Your Honor.
You heard the factual background told to the court by Mr. Montemayor, Mr. Villasana's lawyer. He says, Mr. Villasana lives in Webb County, you live in San Antonio, you have one child with Mr. Villasana, one 6-year-old daughter. Is that true and correct?
Yes, Your Honor.
All right, factual background established. Mr. Montemayor, who is your first witness?
Your Honor, I'll call Julio Villasana.
You are under oath, Mr. Villasana. Listen to your lawyer's questions. Mr. Montemayor, go ahead.
All right. Mr. Villasana, could you please state your full name for the record?
Julio Cesar Villasana.
Mr. Villasana, how old are you, sir?
I am 26.
And you reside in Webb County, Texas?
Yes, sir.
How long have you been residing in Laredo, Webb County, Texas?
My 26 years.
What is your address, sir?
Can you repeat that?
What is your current address?
5530 Buffalo Lane.
5530 Buffalo Lane. And who lives with you in that house?
Yes, my partner and my daughter when I have her, due to my work.
Okay. And how long have you lived at this address?
I got there January 22nd.
Of this year, sir?
Yes, this year.
And where did you live before that?
I was residing at my mom's house.
Okay. And prior to that, you lived with Joanna Rangel?
Yes.
And together you had one daughter, Juliet Mandy Villasana. Is that correct?
Yes.
All right. And how are you employed, Mr. Villasana?
I work for the Texas Department of Criminal Justice as a correctional officer.
Okay. And where do you work?
I work at Dilley, Texas.
As a correctional officer?
Yes.
How long have you been working as a correctional officer?
6 years and a half.
Since you were 20, more or less?
Yes, since I was 20.
And what are your duties there as a correctional officer?
Provide security between inmates.
Okay. And how much do you earn there, sir?
Before pay, I don't know the exact numbers. It's like 5,000 something. After taxes and everything, it's 3,600 flat.
So would you estimate you make roughly about between $60,000 to $70,000 a year?
Yes, around 60.
Okay. And so Juliet is currently living with you. Is that correct?
Yes.
The court had a hearing in January 13th, 2026. You recall that?
Yes.
And the court ordered that your daughter reside with you.
Mhm.
And does she have her own bedroom there at your house?
Yes.
And does she have her own bed and her own bathroom facilities?
Yes, she does.
Does she have her own clothing and her own I guess, toys and things that she plays with?
Yes.
All right. Do you have any other children living in your home?
No.
Okay. Does she go to school, sir?
Yes, she does.
What school is she currently attending?
She's in Prada Elementary.
And she's been going to Prada since when, sir?
January, late December, January, whenever I kept her custody.
Okay. So you've had her in your possession since December. The court had a hearing in January. since you got in your possession, she's been attending Prada Elementary.
Yes,
What grade is she in, sir?
kinder.
And how has she been performing at school?
She's been doing great.
Is she stable there? Any issues there that you've been notified about?
No issues whatsoever. She's been really stable and really good there.
How are her grades, sir?
They're good. A and B's.
Okay. All right. Now, what about her medical situation? When you first got her, you had testified in a prior hearing that you had taken her to a novelty behavioral health.
Mhm.
How is that going, sir?
She's doing way better. She does have anxiety. She hasn't been showing it as often. And also she's gained back her weight as how she used to be.
What do you mean by that, sir?
She has my daughter has lost weight over time, and once I had her like in my possession, she's been gaining her weight back. I believe she went up 8 pounds.
When you say that, did the doctor? Well, when you say that she has anxiety, what was she displaying? What kind of characters and personalities was she displaying, sir?
She would fidget a lot with her fingers. At nights, she will have a sort of trauma where she wakes up fighting and crying. And that has lowered ever since I had her in my possession.
Okay. Do you have her on your health insurance?
Yes, I do.
And who is your health insurance carrier, sir?
Blue Cross Blue Shield.
Blue Cross and Blue Shield. Okay. Do you communicate? Does your daughter have communication with her mother, Joanna Rangel?
Yes, she does.
How often, sir, does she communicate with Joanna?
Most of the time, I mean, daily, whenever she calls, whenever Joanna calls us.
Okay. You were ordered in January. You were ordered. Both of you were ordered to communicate via app close. And do y'all do that?
Yes, we still do.
And that's just through text messages or
And phone calls, yeah, calls as well.
does she have access to video communication as well with your daughter?
Yes.
Okay. Is she communicating presently with your daughter? I believe it was video conference by 7 p.m. every day.
Yes.
She does?
Yes, she calls
Okay.
at that time, most of the time.
All right. Now, what about the visitation with her mother, the exchanges? How is that going?
It's been going good.
Where do you exchange where do you exchange your daughter with her at?
Sometimes in text best at Dili, and when my mom goes to San Antonio, they meet at the 140 mile.
Okay. Let's talk about that a little bit. So what kind of shifts do you have at your work?
I work night shift. It's from 6 to 6, yet I have to be there before 5:30 for the turnout meeting that we have daily. So I wake up around 3:30 and leave Laredo most at 4. Before 4. Mhm.
And how many days a week do you work?
It rotates. I work 4 days on and 4 days off.
Okay. And so when you're not well, let me ask you this. Does your daughter know your mother?
Yes.
They've spent substantial time together. Is that correct?
Yes, she grew up with it.
And so, does your daughter, in your opinion, trust your mother?
Yes.
And so,
More
when
than
you're not available, sir, who takes care of your daughter?
her grandmother, my mom.
Your mom. Okay. All right. So, you're asking that the court award you the right to designate the residence of your daughter. Is that correct?
That's correct.
And you feel that it is in the best interest of Juliet that she continue to reside here in Laredo, Webb County, Texas. Is that correct?
That's correct.
Is it safe to say that you feel she's got a stable home environment here in Laredo Webb County?
Yes, she does.
Is it safe to say that she has a very safe and adequate educational foundation at Prada Elementary, sir?
That's correct.
And do you think that your daughter Juliet feels safe now in your possession and custody?
Yes, that's correct.
And again, I think I've asked you. You feel that this is in the best interest of your daughter.
Yes.
Okay. Now let me ask you about Joanna. I know that we had a long hearing back in January. And there was testimony that Joanna and you had been together how long, sir?
I want to say 5 years, more or less.
5 years. And y'all were living together, is that correct?
Yes.
Where were y'all living together at?
The address was 6115 Monaguillo Drive.
That was here in Laredo, Webb County, Texas.
Yes.
Okay. Now, Joanna, after 5 years, was Joanna working here in Laredo, Webb County, Texas?
Yes, she was working at HEB.
At HEB. And I guess to summarize it, she basically left one day and never came back to Laredo. Is that correct?
Yeah, she left on a Friday, telling me that she was coming following day. She came till Monday morning.
Okay. And you don't know where she was living?
She said she was with her mom.
Okay, but you don't know the address. You didn't
I
find
didn't
all
know.
this information out until later. Is that correct?
That's correct.
And so she took your daughter with her, was staying at some random home in San Antonio, Texas. Is that correct?
That's correct.
All right. How long did it take you before you were able to get visitation with your daughter after she left to San Antonio?
It took me a month, more or less. Yeah.
All right. And would she agree to do this voluntarily, or did you have to file an action in court to get this done?
I had to file an action in court.
Okay. Now, I think at the last hearing, you testified that she was living with random people at this home that she was staying at with her mother. Is that correct?
That's correct.
There were not only Joanna, not only your daughter, not only her mother, but there were other individuals there, boyfriends of everybody was staying at this home as well.
Yes.
All right. You didn't know where she was going to school. You didn't know what address she had. Is that correct?
That's correct.
Okay. And it wasn't until the hearing in January that you were able to find out exactly where she was living at now.
That's correct.
Okay. And you found out again in this prior hearing that she was residing with some other individual now, correct? Another partner of hers.
Correct.
Okay. And before that, she also had another partner named Brian. Is that correct? Brian Alvarez.
That's correct.
And then now she was with another individual named Gilberto Perez. Is that correct?
Yes, that's correct.
Okay. And this Gilberto Perez, to your knowledge, had some kind of criminal history. Is that correct?
Yes.
All right. And so do you know what kind of medical care or treatment your daughter was getting in San Antonio, sir?
No.
Do you know if her health or safety or welfare was at risk by continuing to live with Joanna? Did you hear me, sir?
Yes, yes.
Do you feel that her safety and welfare was at risk if she continued to live with her mother?
That's correct.
Why, sir?
Well, I don't think she was having a proper care. There's many stuff. Like that time that she gave my daughter back to us when we were picking her up, and she had no underwears. There's times where she wasn't having any footwear whatsoever. She will always come home with, I guess, like with a runny nose, not knowing if she had any allergies or whatnot. Now that she's with me, that's gone. All that kind of runny nose or flu she ever had over there is well taken care of over here.
The anxiety is
The anxiety, we had to work with it little by little, but it's getting better.
all right. All right. Do you believe that if Juliet goes back to her mother, that there could be a disruption in her with her anxiety and her peace of mind?
Yes.
But she's currently visiting with her right now. Is that correct?
Yes.
And how does she act when she comes back to you after her visitations?
Well, there's times where she seems worried, but for the most part, I think she's done better. She knows, and she tells me not to worry about her. It's just 2 days. I'll be back shortly, in Spanish, of course.
All right. So you're asking you're asking the court to name you as the managing conservator, the one with the right to determine the primary residency. That's correct.
That's correct.
You're asking that the court continue to the status right now is that Joanna visits how often?
Every first, third, and fifth weekend.
On Friday at 6 o'clock?
Yes, Friday to 6 p.m. and all the way to Sunday, 6 p.m.
And you meet halfway in Dilley, Texas, or your mother takes her to San Antonio.
In case she goes over there, yeah.
Okay. And so you're asking for that to continue?
Yes.
Okay. Are you asking, you're not asking for any child support, is that correct?
I'm not asking for any child support. I just want her mental health and stability.
And you're asking that, and you're willing to continue paying the health insurance for Juliet?
Yes.
Okay. And you're also asking that whatever is not covered by health insurance, that you and Joanna be ordered to pay half and half.
Correct.
Are you asking the court to continue with the communication via app close, sir?
Yes, that will work.
And you're asking that the same orders that were in place in January continue as they were ordered to do back then, as they were ordered back then.
Yes, sir.
Okay. Do you know what Joanna does nowadays? Is she working? Do you know?
No.
Do you know if she's had another child? Is that correct? That you know of?
She has had another child.
Yes. With this Gilberto Perez.
Right.
Okay. All right. Is your daughter currently in any, suffered from any serious medical conditions while she's been under your care?
No, she's been good.
Okay. Do you know if Joanna was able to meet with the medical professionals when she was when she was evaluated in January?
Can you repeat that question again, sir?
Was Joanna ever did she ever meet with any of the medical professionals
No.
that evaluated your daughter?
No, but I did tell her, so she's aware of it.
Okay. What was it that you told her, sir?
I told her, well, her health issues at this point, right? How she will act, and also that I have taken it to a psychiatrist that she got referred by her doctor at that time, Norberto Alvarez.
Okay. All right. And you don't know if she ever was able to communicate with any of them?
No.
Okay. Okay. Your Honor, I'll pass the witness, sir.
Ms. Rangel, do you have any questions for Mr. Villasana? Please unmute your device.
Yes, I do, Your Honor.
Go ahead.
Okay. Julio, are you aware our daughter takes 2 snacks to school to try to make friends?
Yes, I do.
Okay. And are you aware that our daughter was being bullied by a 10-year-old at her school?
No.
Okay. And then, Did you follow up with her psychiatrist medication?
I'm not giving her any medication at the moment. She's done better.
Okay.
I don't see there's a need to.
Okay. Did you continue taking her to her psychologist therapies?
I've taken her to a after a psychiatrist, I've taken her to a psychologist. Yes.
Okay. Did you follow up with those psychologist therapies?
Not at the moment.
And can you remind me why does her daughter take melatonin at night, please?
She struggles to sleep.
And up to this day, she still struggles to sleep?
Not really. She's done better.
Okay. And then, and you don't remember the night I left, right? After you were being abusive towards me. You don't remember the night.
No. Yes, left.
So you don't remember hitting any walls in this residency where we used to live at 6115 Monaguillo Drive?
No.
Objection's been asked and answered, Your Honor.
Sustained.
Okay. And then, you don't remember changing the appointments to her psychiatrist last minute, preventing me from going to see her?
Preventing you from going to see her. No.
Okay. And then, do you remember, I'm sorry, do you remember that day behind the Whataburger?
No.
You don't remember being abusive towards me behind that Whataburger?
Objection's been asked and answered, Your Honor.
Sustained.
And then, let's see. Is Juliet staying with you daily?
No, I work night shift.
Okay.
My mom takes care of her when I work.
Does Juliet spends more day at her grandma's house than yours?
It's even. I work 4 days on, 4 days off.
Okay. And on April 14, your first day off, did you pick her up or drop her off at school?
No, my mom did me that favor.
Okay. Okay. Let's see. And then for spring break vacation, did you follow the standard possession order?
Which was?
Since she's residing with you, she was supposed to come with me for spring break.
I didn't have her last spring break, so I had her.
You kept her.
Yes, I kept her.
And then, do you think your work schedule doesn't allow you to be with our daughter?
It does allow me to be with my daughter on my days off. I work night shift.
Okay. And there are 12-hour shifts, correct? With a 3-hour drive in total?
Yes, 2-hour drive, yes.
Okay, and think those are gonna be my questions. Hmm, I'm done, Your Honor.
Anything on cross-examination, Mr. Montemayor?
Yes, Your Honor. Well, I don't have any recross, or I don't have any direct for my client. I'll call Joanna Rangel.
All right, on direct, go ahead.
Ma'am, what's your full name?
Joanna Elizabeth Rangel.
And how old are you, ma'am?
I'm 25.
25 years old. And you currently reside at 4903, was it Warhorse Drive?
No, I gave my new address to Julio, which is 12436 Vance Jackson Road.
Vance Jackson.
Mhm.
And you live with Gilberto Perez, that's correct?
Yes, my husband.
Yes. And you and Gilberto Perez have been together how long now?
For a year. A year and 4 months or 3 months.
And so before the hearings in January or in December, Juliet, your daughter that you have with Julio, lived with you in Gilberto Perez.
Back in December, no.
In December, before the hearings that we had here, that we're here now on again, your daughter resided with you in Gilberto.
With me and my mom.
Okay,
Back in
with you.
December.
In December 2025, with you and your mom?
Oh, December 2025, yes. Yes.
Okay. And so, did you ever speak to Dr. Alvarez from the Novelty Behavior Health of Laredo?
I did try calling his office once, but I wasn't able to reach out to him. It was through to her assistant.
Did Julio ever talk to you about what Dr. Alvarez had indicated?
Yes.
Okay. Did Julio tell you that that some of the anxiety that your daughter felt may have been triggered by your husband, Gilberto Perez?
No.
You were not aware of that?
No, he mentioned that it was because of me, not because of my husband in the beginning.
Now, did they ever tell you that there may have been an outcry by your daughter of some inappropriate touching by Gilberto Perez?
He never mentioned it, just to today when we were trying to make the agreement, he mentioned that.
Okay. And so you never actually followed up with Dr. Alvarez. You questioned Julio about it, but you never actually followed up with the doctor yourself.
Not with Alvarez, but with the psychiatrist. It was first the psychiatrist, then the psychologist.
Okay. Do you believe it's important, ma'am, that your daughter have a stable home environment
Yes, I do.
and that she be not exposed to perhaps dangerous situations or strangers? You believe that that's proper, that she be protected that way?
Yes.
Okay. So why is it that when you moved over there in San Antonio, you lived not only with your mother, but with at least what I count 6 to 8 different people? Your daughter didn't have her own room, didn't have her own place to sleep, and just had random people coming in and out. Why is it that that situation occurred? If you think that your daughter should be protected and have a stable home environment.
I don't know where they get that from because we did have our own room here. It was my mom, her husband, and my siblings living here. CPS came, he confirmed that there was nobody else in the house. They ruled out the cases when he was making allegations against me. We had wellness checks too, welfare checks that he was doing. We had like 3 or 4 of them, some at midnight, some during the day.
Why do you say that he was doing it? Do you
Who?
have report that says his name on it, that he was the one calling?
Yeah, he would tell me. He'll be like, oh, they would tell me also from his behalf.
Okay. So what do you do for a living, ma'am?
I'm a stay-at-home mom.
Okay. So you don't work?
No.
Okay. And have you gone and checked on Juliet's grades and her performance at school?
Yes, I have.
And you would agree that she's doing good? That she-
Yes, with the grades, yes.
Yeah, that she's a smart child and she's doing.
Yes.
Okay. And do you agree that she's gained weight now and a lot of her anxiety has gone away?
She did gain weight. Her anxiety, I still notice her cryings here. Before I wouldn't notice them, but lately I've been noticing her wanting for me to be always with her. Regarding going to the restroom or showering, she wants me there, sleeping with her. Also, she wants me there with her, and I do that, stay with her.
Could that be because she's afraid of Gilberto Perez?
No,
That's why she wants you near and needs to feel safe when she's with you because she's afraid of Gilberto Perez?
no, she's not afraid. She actually calls him papi too, and every time she sees him, she goes running up to him. I have pictures and everything. She likes to be carried by him, and she likes to be around. She feels very comfortable being around him.
Okay. Let me ask you this, ma'am. You have communication with Juliet every day?
Yes, I do.
And you've got access to video conferencing as well with her?
Yes, I do.
And you've been pretty good about exercising your visitation and meeting up in Dili or meeting in San Antonio. Is that correct?
Yes.
Okay. Would you agree that Juliet knows her grandmother? In fact, grew up some years with her grandmother,
Yes.
and so her grandmother's no stranger. So if Julio's unavailable and then she stays with her grandmother, it's not going to be a shock to her. She has a good relationship with her grandmother.
Yes, I agree. She's safe.
Okay. And so, do you also agree that that you've not been paying any child support in the last several months, correct?
Correct.
Right. Now, would you agree that if this court were to grant Julio the right to determine the residency of Juliet, are you okay with not paying Julio any child support?
Yes.
Are you also in agreement that Julio continue to provide the health insurance for Juliet?
Yes.
And you're also in agreement that if the court were to grant Julio the right to determine the residency and Julio continues to provide the health insurance, that anything that's not covered by that health insurance be split equally between you and Julio?
Yes.
All right. And so you're good. You've got a pretty good a pretty good visitation schedule. The first, third, and fifth weekends from Friday to Sunday.
I'm sorry, can you repeat that question?
Did you have a good visitation schedule? Is that correct? You're currently visiting okay with Juliet?
Yeah, of course I would like more time. She's my daughter, but
Sure.
yeah, currently we're
And that's something we can work on.
every
We can always work on more time. How old is your child now?
She just turned a month on the 14th.
1 month. Okay. And now, do you think it's in the best interest of Juliet, Joanna, that she have a stable home environment?
Yes.
Do you think it's in her best interest that she have a stable school environment?
For the school, I'm a little concerned for those extra snacks that she's taking and the 10-year-old.
Okay. But do you think it's important? That's not what I asked you. I asked you, do you think it's important that she have a stable school environment?
Oh, yes.
And so, and you've testified that you think she's doing good at school and you think that she's got a good home here in Laredo. Is that correct?
Yes.
Okay. I'll pass the witness round.
This is your opportunity, Ms. Rangel, to tell the court anything you'd like. What would you like the court to know?
Yes, Your Honor. During the father's parenting time, our daughter is not primarily in his care. She's staying with her grandma most of the week due to his work schedule. I respect that he works. This means he's not consistently available to meet her day-to-day needs. When I am available and willing to provide that stability and direct care for her. And I believe it's in the best interest of our daughter to be with the parent who can be present. And then I can provide that direct consistency care, and that's better for our daughter, in my opinion. I do agree that she is safe with her grandma, but the issue is not safety, it's consistency and parental involvement. I believe our daughter benefits more when the parent is present, especially with those anxiety and that she has. There's nothing wrong with her helping, Your Honor, the grandma. Like, I really appreciate that support from her. My concern is that's happening on a regular basis during most of his parenting time, and when I'm available to provide that care myself for her. And also him being almost 12, 13, 14, almost 14 to 15 hours away from her makes me be a little worried, because in case of any emergency, I know the grandma will be there, but again, the grandma also has a teenage boy that she has to take care of.
What else, if anything, would you like the court to know?
The stability, I think how is it stability for her? She went from 2 houses now to 3. It's his grandma's house, my house, and his house now. So she's moving around too much over there in Laredo too. That's my damn concern. And what else? Yeah, it's mainly that he's in daily 12-hour shifts, an hour and a half driving. That's what I'm concerned of. Then I had given him our daughter's Medicaid, so we can do the sessions without having to spend money out of pocket, but I don't think we follow up with that since her psychologists are here in San Antonio. Like that accept that insurance. The ones in Laredo don't accept the Medicaid insurance from the psychologist, so we can continue her therapies over here without a problem. Her doctors are here too. Well, they used to be here when she was here. It was Alamanoy Pediatrics. She can continue having regular visits so we can keep track on her weight so she doesn't lose any weight. What else? My husband, he did had a criminal record, but it was back in 2020. It was about evading arrest detention with a vehicle, but there was no drugs, nothing involved. Like, it was just him running away from the cops. But he did everything to get it out of his, like, not his record, but he did everything. There's no concerns on that. And he's a good dad. He has a daughter too in McAllen. He does visit her and everything. She comes. Juliet spends time with them too. So I don't think the problem is with him. I think it's Juliet mainly, like, being around houses too much. That's what making her anxiety. And of course, I believe that her not having her dad there all the time too, maybe that's why she wants me to be there, taking her to the restroom, taking her to the shower, sleeping with her. I feel like she needs that parent to be there with her so she could feel more protected. And since I don't work, I can provide direct consistency care and be there for her, present. Since I don't work too, I can be in the house with my 2 daughters. I will pick her up and drop her off from school when she was here, every day. And I know over there she has to be the grandma some days, the dad some days. It's just too much switching on over there.
All right, Mr. Montemayor, anything in redirect?
No, Your Honor, just argument.
All right, so Mr. Montemayor, Mr. Angel, I'm going to give you a couple of minutes to make your closing statements. What you need to tell the court is, tell the court what you want the court to do, and remind the court what the court heard in evidence and testimony to support those requests. Mr. Montemayor, go ahead.
Your Honor, we're asking that the court name the parties joint managing conservators and that the court name Julio Villasana as the party to designate the primary residence of his daughter, Juliet Mandy Villasana. The court heard the testimony from Mr. Villasana, and the court, and I'll remind the court what the testimony was back in January. But basically, Mr. Villasana has, stable employment, has been working for over 5 years with the Texas Department of Criminal Justice as a detention officer. He makes a very good, handsome salary between $60,000 to $70,000. He's got a stable home. He lives with his partner, and Juliet is the only person the only child in the house that has her own room, has her own access to entertainment, has her own access to her facilities, and is very safe and stable. Even Ms. Rangel agreed that she's has a stable home environment and that Julio has very stable employment. Mr. Villasana provides for her medical needs, her home, her medical insurance, Blue Cross Blue Shield through the state of Texas. He provides the access to the schooling with Prada Elementary. She's a kindergarten student. Has he moved? He was living with Ms. Rangel up until she suddenly managed to walk away and disappear. According to her, there was an abusive relationship, but there is not a single report, not a single arrest. Mr. Villasana has a record of with no arrest, which I can't say the same about her current partner. But he sold that house. He paid off the debt that Joanna left, and lived with his mother until he was able to get back on his feet and get the house where he lives at now. This is not a situation where he's jumping from home to home to home, because he's either trying to escape from something or he can't afford anything, and so he's basically going through the phases of reestablishing his home environment, his stability there, because they were together for 5 years. And so, I'll remind the court the testimony that the court heard in January now, when Ms. Rangel left in November 2024, she left without any notice. She left without leaving a contact or communication. She had blocked Julio out. There was no access. It wasn't until a month later that he was able to actually see and speak to his daughter again. At this home that they first went to, talk about jumping around. She was living with her mother first, in a house where her mother's boyfriend lived, her sister's boyfriend lived. They had workers going in and out of the house. Her other boyfriend, Brian Alvarez, was living there. And then she met some other guy named Gilberto Perez and moved to 4903 Warhorse, and now lives at 12436 Vance Jackson Road. That's three different residences. So if she wants to make that claim that Julio is moving around, she's pretty much guilty of the same thing. At the end of the day, Judge, what stands out to me is this: she's not concerned about her daughter's health or welfare. The psychological issue, the evaluations that we have testified about in January and now indicate that Juliet felt some anxiety towards her mother's new husband. And I think that what Ms. Rangel testified to as far as her daughter's reaction when she is with her is indicative of somebody who does not want to be left alone, is indicative of somebody who's scared, who needs that constant, be right here, be next to me. I understand children, get scared, but sometimes, but I think from what I gathered, doing the math, what the doctors indicated is that she expressed some anxiety towards this gentleman, and so going back to where this person is present, can create again some type of anxiety, some fear, and I think this is a response to that kind of stress. this little girl has a very stable school environment. There's some indications of bullying. I don't know. I know children go through different factors, but even Miss Angel agreed that she's got a very good school environment here. She's healthy. She has gained her weight. There is she even has doctors for her that have some apparently some psychological training in San Antonio. So Juliet has been acting out apparently even when she was under Miss Angel's custody. I think Mr. Viasana can provide a stable home environment, a safe home environment, a healthy home environment for his daughter. I believe the visitation is adequate here. First, third, and fifth weekends, he's driving, or his mother is driving the child to drop off, and Mr. Angel has access. He's not asking for any child support. He'll continue to provide the health insurance, and I think this is in the best interest of his daughter, that she continue to thrive as a child, which she's apparently doing now. And so we don't want to deny Miss Angel any access. We've even there's been access through the app close, through the video conferencing. And so there's that relationship that Mr. Viasana is encouraging. And so I asked the court to continue with what is there already, continue the current conservatorship, the current primary residency. I think that any change in the current structure for Juliet, would be troubling for her. Could potentially cause her more anxiety, especially with going back to somebody that where somebody is that she does not feel comfortable with. And so I asked the court to name Mr. Viasana the managing conservator with the right to determine the primary residency, and continue the orders that are currently in place as ruled on January the 13th.
Mr. Angel, this is your opportunity to tell the court what it is that you are requesting, and remind the court what in evidence and testimony here today supports that request. Go ahead.
Yes, Your Honor. I'm requesting also the joint managing conservator, and for her to reside with me. Like we said, the issue is not safety, it's consistency and parental involvement. I believe our daughter benefits more when the parent is present. Due to me moving around, yes, I did had to move from in a short amount of time due to my high risk pregnancy. The hospitals were too far, and I needed to be seen by the hospitals twice a week for my pregnancy. That's why we moved. We had to move closer to the hospitals and closer to my mom also for her to help me out. But now my baby was born fine. Everything's good. And Juliet, she does have her own room here too. She has her toys, and everything like she has over there. There's not an issue with that. She picks out her room decorations too, her themes and everything. There is a police report back in 2024. I didn't put any charges against Mr. Villasana, because I was thinking of him on his job and our daughter. That's why I decided not to put any charges. Another thing, I do believe she will benefit more from more stability and time with a parent who is consistently available to meet her emotional and daily needs. Like I said, I'll be there for her to pick her up from school, drop her off from school. I want the best for her too. She's our daughter. And I do believe that Julio's working schedule doesn't provide that at all. Like we said, 12-hour shifts, 3-hour driving time. In case of any emergencies, the grandma's gonna be there when I can be there for our daughter. I'm the mom and I'm not working. I'm a stay-at-home mom. If my husband is a concern, we can do something about it. But I have videos, I have pictures where they're together, where she goes and hugs him. She's always like, papi, papi, like, especially now with her newborn. She does, she's been since her younger sibling was born. I've also noticed that she has a difficult time during transitions and becomes very upset when I drop her off. She wants to spend more time with her, and of course they're sisters, but she's excited to be the big sister. And about her and her anxiety, I brought it up because she wouldn't do it here when she was living with me. She wouldn't ask me to go to the restroom with her. She wouldn't ask me, oh, shower me. She will shower on her own. She will go to the restroom by herself. But now she does ask me to always be there for her. But I believe it's because her grandma does it with her, so she wants to do it over here too, which it's totally fine with me. I'm there for her, so and I have the time to be there for her too. Um, podemos escribir a Sanano. We can continue doing the 2 weeks. I know it's very difficult for us to come to an agreement due to his working schedule. It's 4 days on, 4 days off, so 4 days out of the week he's not with Juliet. That means she has to stay with her grandma for 4 days straight, and maybe a fifth day while he gets his energy back up from work. So that's almost 4 to 5 days throughout the week that she stays with her grandma and not with her dad. And I'm okay with him visiting. If he has any time to come over here to San Antonio during the week, to come see her, I'm totally fine with that. If he wants the child support, we can keep it at the minimum. I'm not concerned of that. For summer vacations, we can maybe extend his summer vacations if he wants to. So he can spend more time with her. But yeah, I would like for Juliet to reside with me so she can, so I can be more with her and I can be there to meet her needs and wants, since I don't work. And what else? Yeah, that would be all, Your Honor.
I just have a couple of questions. I need this crystallized for the court. So there was a hearing in January, and based on that hearing, whatever evidence and testimony was presented, the court made some decisions. And based on those decisions, just temporarily until we get to the final hearing, we're here at the final hearing, temporarily, this child was to reside with Mr. Villasana. So I guess what the court needs to hear, crystallize this for the court, Mr. Rangel. So there has to be a good cause, a reason, a basis to change those temporary orders and do something different with final orders. What do you believe factually, and what did the court hear in testimony today? What's the good reason, cause, or basis to change those temporary orders?
The good reason will be, so she can have a parent present with her at all times. She can, very much, we don't have, like, we do have our parental responsibilities, but they're being given away to her grandma for 4 to 5 days throughout the week, which I don't think it's fair for the grandma either, since I'm not working, I can be under her care and he can visit her, or either or.
And I guess the follow-up question to that is, what is it about the temporary orders that are not working, and specifically not working for your daughter? In other words, set yourself aside and set Mr. Villasana, because what the court needs to focus on is just your daughter. That's the only concern the court has, is what is in her best interest. So you tell the court in your own words, what is it about the temporary, like the current situation, the temporary orders, that is not working for your daughter?
I believe the direct care for her, the consistency and the parental involvement. I believe her daughter benefits more when the parent is present. That's why she's been having those anxieties. She feels left alone maybe by her parents, since she's mainly with her grandma most of the time.
All right, so let me give you a decision, Mr. Villasuena and Ms. Rangel. Keeping in mind that the only thing that the court focus on is what is in this child's best interest. That's it. Not my concern about Mr. Villasena's well-being or Mr. Rangel's well-being, although I think both of you have had some transitions, and that's okay. People need to grow and change and learn and do and figure things out and what's good for you. But my job is to figure out what's good for your daughter. And in this situation, one more time, I need to figure out what is in her best interest. But I guess, you know, the facts in this case, I'll put it to you this way. The facts are sparse in terms of what the court has to hang its hat on to figure out what is in the child's best interest. And I think the best indication that the court can have or does have, and it's agreed to by both sides, is the child's schooling. Right? Because if the evidence and testimony was that this child is under anxiety or not being taken care of or all these things, then the biggest indication could be, in this case specifically, the school. Now, if there was an allegation and then the grades are affected, if there was an allegation and there's a large number of absences, but that's the best indication in this case that the court has as to how this child is doing. And I think the court heard from both sides that the child is doing good in school. That's the best factor that the court can weigh to see, is this child doing well or is this child not doing well? The court did hear testimony about bullying and then didn't hear any follow-ups. And then the court also heard testimony about some cookies that were being offered, I guess, as a appeasement to some other student. But if there was a big effect, then the court would have heard testimony or evidence about bad grades, missed days at school, counseling sessions, all these things. The court didn't hear that. So the best the court can determine is that this child is doing good and well based on the outcome at school. And that outcome is, she's doing well at school. So I'm going to tell you, Mr. Angel and Mr. Villasana, what the public policy of the state is. Texas, the policy is that children have close and continuing relationship with each and both parents. So based on all of this, the court is in cause number 2024 FLC 1931C3. The court has not been provided sufficient information in the record by evidence or testimony to make any changes. For that reason, Mr. Villasana and Mr. Angel, both of you are appointed joint managing conservators, which means that both of you have and continue to have the same rights, duties, responsibilities, and obligations over your child, except that you, Mr. Villasana, will have the exclusive right to determine her residence. By your request, child support is set at 0. Those are the orders of the court. These orders are, and standard visitation, including for those parents that live more than 150 miles apart. These are the orders of the court, and the orders are due to the court on or before
May 18 at noon by submission.
Ms. Flores, does the court have Ms. Rangel's email address?
Yes, Your Honor.
All right, Mr. Villasana, do you have any questions for the court?
No, sir.
Ms. Rangel, do you have any questions?
No, sir.
Anything else on this case, Mr. Montemayor?
No, sir.
Mr. Villasana, Ms. Rangel, I wish you both very well, but more importantly, I wish your daughter all the best. I wish you all good luck.
Thank you, Your Honor.
Thank
Have
you.
a good day. Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor, all cases have been called.
This now concludes this docket held in person and by video conference at Webb County Court of Law 2 for Thursday, April 16, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court of Law 2 staff and the employees of Webb County that provide judicial support to the court. The court thanks you all and wishes you a good night.